Good morning, everybody. Happy Monday. Welcome to the Courtroom Files Live. Let's get the week started with Judge Dad.
October of 25. She also pled to the alcohol-related charge of operating while impaired. I've given her multiple adjournments. She took great exception to the report that I read to her. I believe it was the first sentencing date where she was, I don't know if you've had a chance to review the police report.
I have, Your Honor. I've been able to review the PSI, talk to my client about this situation, be ready for CB sentencing.
You read the police report?
I've not read the police.
You might want to read the police report. You want me to give you a copy of the police report?
I would. I mean, if that's like this court wants, I mean, would you consider a week adjournment and you're just retained or?
No, I told her last time. You can take all morning if you need it. She's asked for 4 adjournments. I mean, this is ridiculous. She's fired lawyers. She's.
No, Your Honor, as I said, I don't need to read the police report. Honestly, be ready to proceed with
All right, good enough. So she pled to those. Have you had a chance to review the report with her?
I have, and Your Honor, if I might, my client is, as you've given her adjournment, she's pretty familiar with everything. She's filled me in with all the details. We've had a discussion that's covered everything. We'd like to proceed if that's okay.
No, that's fine. I don't have any issue with that.
And again, also after reading the PSI and discussing with my clients, there are no additions, corrections, no deletions that need to be made. Just simple allocution.
Okay, go ahead.
And I'll just start by saying, Your Honor, my client was not trying to be difficult with this court or with anyone. This is a big deal. This is a big step into something bigger.
Well, it's not too big of a deal. She's had multiple convictions, right?
So I see the possession of marijuana charges.
Well, yeah, it's more than that. You kidding? I know we're going back to 06, but larceny in a building, possession of a controlled substance 09, possession of a controlled substance 10, possession of a controlled substance 15, drunken disorderly 22, domestic aggravated 22, leaving the scene of a property damage accident, disturbed the peace, and she also had the operating while impaired from 18, operating while intoxicated, it says in here. So
Understood, Your Honor. Understood.
I'm just telling you, you got your work cut out for you on this one. I don't want to blindside you. Okay?
Yeah.
So you can go ahead and proceed.
So, again, I just want this court to know that after speaking with my client, at least when she's retaining me, she's taking full responsibility for everything that happened. She's went over the details of me and how this matter came about. And I've had a good opportunity to talk to her, Your Honor. I want you to understand that I did go through her criminal history. And I have had, a discussion with her about that. And she's been very upfront and forward with me. Very, very forward. Now,
About what happened at the scene?
the past case, Your Honor.
Okay,
everything.
good.
I want you to know she's taking full responsibility. Okay, Your Honor. She understands that she has decided in the past to now go down a path that she's much better than. My client's an entrepreneur. She has a 3D printing business. She does that, and she has every tool and opportunity to her to be very successful. And if she continues down the path she's going on, she's making a poor choice that's going to ruin the rest of her life when she has every opportunity to do much better than she's showing me for. She has been excellent on bond, Your Honor. She's had no bond violations. I'm going to ask this court adopt that recommendation because I do think, Your Honor, that with the correct help and push and guidance, she can go down and the path this court and everybody here wants her to go down, Your Honor, and improve and be better. And I know she's going to be better. If this court just adopts the recommendation, I think the goal of the court will be met, and I think my client's going to do better off front.
Anything you would like to say, ma'am?
I would like to apologize to the court for all the delays and that I understand my mistakes and I want to be on the road to make my life better.
I don't want you to apologize. I don't want you to apologize for the delays. I do want you to recognize that I don't appreciate you coming in here, looking me in the eye and telling me none of this happened. I can handle a lot of things. I can't stand when somebody stands there 20 feet from me, looks me in the eye and tells me something. It's untruthful. Now, if this police report is false, as you made it sound before, this officer has no business not only being a police officer, but carrying somebody's garbage across the street. You don't take on police like this. I opened my door and issued multiple commands for the driver to return to the vehicle. She immediately stated no and mentioned I would have to kill her. The driver began taunting me and verbally refusing my commands to return to her vehicle. I requested additional units and attempted a fifth and final time to order the driver to return to her vehicle. And she said, "Are you going to kill me?" No. Then what are you going to do? We don't do that. This is not a lawless country. I know some think it is, but it's not going, ma'am, look at me when I'm talking to you. We don't do that. We don't do that. Now, police are wrong sometimes. I'll be the first one to tell you that. Judges are wrong sometimes. But you don't get to do this. And your record speaks volumes about how law-abiding you've been. You can't do this. And then she berates her last court-appointed lawyer, how he didn't tell her these things, and fires him. And that's all fine and dandy, but Mr. Crawford has my utmost respect. Comes in here, works hard for people, does the best he can. But I want you to know the decision I'm going to make here, how do I say this? It's based on your record. It's based on the fact that you consistently violate laws. And that's what judges do. At least that's what this judge does. I'm going to place you on probation for 24 months. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, your place of employment, or home telephone number, you must notify probation. You have to report as direct. No alcohol. You're not to purchase, possess, or consume alcohol. You're not to purchase, possess, or consume illegal controlled substances. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're going to be on a... Now, counsel, if she thinks she can get here, she lives in Warren, right? I'll take her in sobriety. I'll take her in sobriety court. She won't go to jail today. I'm going to let you, and you know what I'm going to do, just to be completely fair about this? Do you have another court you have to go to?
Exam, actually.
Okay, look.
In 36.
Look, what time does that start? Okay. Here's what I'd like you to do. Let's adjourn this. You go down and you speak, but it's going to take a commitment from her. She's going to have to come here.
No sobriety for a while.
Okay? And if she wants to do that, she's going to turn her life around, and I'm going to help her do it.
Absolutely. I appreciate that.
You want to adjourn it a week?
I will adjourn it, yeah, if we can.
You give me a date that's good for you next week. But I want you to sit down, or at least her to sit down with probation today to see whether she wants to do it. And then I would put her on a bond phase. When you guys show up next week, I would put her on a bond phase for 4 weeks. You give me a date that's good for you.
What, is Friday, do you do Fridays or not?
I do Fridays, but I'd rather not do Fridays.
Fair enough.
If that's all I have. I mean, do I have anything scheduled on any of these Fridays, Lisa, coming up?
On the 12th, is that
You
the date
wanna
we're
do-
looking at?
Want to do the 12th? Do I on the 12th?
Let me look.
I was looking at next Friday, next week. But I mean, I guess we could,
Hang on.
we
Let,
could do this Friday.
do I have
Nothing on
some-
the, nothing on the 12th or the 19th. Judge Hessen does have a jury trial on the 12th.
Okay,
I could do this Friday.
I'll do this Friday for you.
Does that work?
Absolutely. We'll
I think that's
adjourn,
ample time.
we'll adjourn this until, we'll make it 9 o'clock in the morning on Friday.
Perfect. I appreciate that, Your Honor. Thank you for working.
But I'm telling you, I need her to consider sobriety court.
I'm picking up for your, I practice here a lot. I completely understand.
And if she shows me a different attitude, she and I are gonna get along great. She's gonna actually like me in 2 years, believe me.
Sure, quicker than-
Go down the hall, get your notice. You're all set, man. I hope you'll consider it. Counsel, I'm gonna get you out of here as soon as I.
Good morning once again, everybody. Happy Monday. Welcome to the Courtroom Files Live. Before we go any further, a happy birthday to Michael Groff, weatherman extraordinaire here in Arizona, co-host of Sidebar, substitute host here at the TCF Morning Live show. Just an all-around good guy. So Michael, my friend, happy birthday. I hope you have a great day today. Let's leave a feisty Judge McNally behind for a moment. I'll keep an eye on him, but let's head a little bit north to Judge Elmore. I believe he's going to do a sentencing.
Thank you. You all may be seated. The court also recognizes before Mr. Kevin Stapleton, state from the Michigan Department of Corrections, and prepared today's pre-sentence investigation report. We're here today for a sentencing in this case involving no contest pleas as to 2 counts. One count is for assault, resist, destruct a police officer, and the other is for an attempted assault with intent to do grave bodily harm. Take a quick look here at the PSI and see if I had any notes. I did not have any notes for corrections. How about you, Ms. Carey?
Thank you, Your Honor. I do have 3 challenges to the scoring.
All right, let's take a look.
OB1, Michigan Department of Corrections scored it at 5 points.
That's for the second count.
Sorry, yes.
Yep, that's okay.
It's all with intent. She scored at 10 points because the defendant put a belt around the victim's neck. He actually was touched by a weapon.
Let's take a quick look here at the description of the offense. I read it last week.
It's on page 3.
Yep. One second.
CFJ 284.
There's another point that I was thinking about. So, 1 second. Mr. Harrison, your response?
I believe that Mrs. Carey's application of the offense variable is consistent with the facts of this matter.
All right. I had also was considering there for a moment the language where it says, but I don't think it's going to be scored. It's underneath the description of the offense on page 2, CFJ 284, where the dog was sick on her as well. So, I didn't know if that meant she was bitten or.
The answer is yes.
So I think, and I don't think any of that is going to elevate.
I have two more after this.
Yeah, all right. So at least for offense variable number one, I don't think that applies to offense variable number one. However, I do apply the 10 points based upon the strangulation activity. Thank you. Your next one.
Thank you. I next would challenge OB3,
Okay.
which the department scored at 0. She did have bodily injury requiring treatment. She had several wounds.
Yeah, I saw the lacerations that were mentioned on that page 2. And a bloody nose, marks on her stomach. I don't know what that meant, but it also said at the very bottom, she was left to be treated by EMS. Were there any other factors there?
No, I mean,
No.
in the next sentence in the paragraph says she was re-interviewed at the hospital. She was
Yeah,
treated.
Yep. All right, Mr. Harrison, doesn't sound like there's too much there to agree with.
I would concur with that assessment.
So we're gonna change offense variable number 3 from 0 to 10. So far, that's changed our total OV from 17 to 37. But Ms. Carey, you said you had another one.
You, I would challenge OB10, which is scored at 0. And I
Okay,
think it should be scored at 10 points for exploitation of a vulnerable victim due to the difference in size and strength. The victim in this case, not here today, but is his mother, who is definitely smaller and
how it looks like here the defendant is 40 years of age, so she must be at least somewhere in her 60s. Not that that is overly old, but I don't know anything else about her.
I would say she's definitely weaker and smaller.
Is there anything there in your descriptions within the police report that helps me understand a little bit more about her size and age?
I didn't see it in
Color me.
I did not see it in the PSI.
Do they reside? Were
They
living?
were residing together.
All right,
at
so
the
now
time.
not only do we have some question about age, but also domestic relationship.
So her date of birth is
1956.
1956.
Oh, so she
She's
is
10 years older than I am.
Okay, so yeah, mid-60s. Yep. So, right. 46
Late
plus
60s.
25, 60, 71. No, 69.
She's 69.
All right, thank you. All right, the court will score 10 points of offense variable 10 based upon age, size, but also domestic relationship. All right, thank you.
Thank you. For the count 1, just an obstruct. I think that OB1 should be scored because he wielded a golf club iron at the officer.
Okay, and 1 second. That how many points?
5.
5. Mr. Harrison, it says the weapon was displayed. I think it's probably just a minimum of 5 points. Anything to say or in response? Anything else, Ms. Carey?
No, Your Honor, thank you.
All right, so hold on. Before I turn to the defense.
Pretty drastically changes the guideline range.
Yeah,
At least that's to count 2.
yep, let's take a quick look. I doubt it makes any change. First offense, we are on a class G for offense 1 that does not change the scoring at all. That remains 0 to 9. However, as to the Class E and Count 2, that changes, that gives us a total of 47 points. And that's going to increase the guideline range from OB level 2 to an OB level 3. And that puts us at a 2 to 17. All right. Thank you. Any other changes to the body of the report at all, Ms. Carey?
To the body, what?
Do you have a question?
Yeah, on OB 10, did we do 5 points or 10 points?
Thought we did 10.
I think, honestly, I think it's, well, no, never mind, that's right, 10.
Yes.
Sorry.
Add, okay. All right, Mr. Harrison, any other amendments, corrections, or objections to make to the contents of this report?
I sure hope not. I don't have any to propose.
All right. I see no victim impact statement to be made here today in person. Allocution, I know there was one inside the report. Allocution, Mr.
Well, two things should jump out at you when you first read this report, not the least of which is that Mr. Burrows has been incarcerated for 191 days. If you dig a little bit deeper in the file, you will see that part of that time was devoted to an evaluation of his overall competency / criminal responsibility. That dovetails nicely with the next part of my discussion here, because when Kevin first came into the jail, the issue of competency became to the forefront of my thinking, because he was virtually non-communicative with me. He was unable to formulate complete thoughts, complete sentences, and seemed very, very confused by even the simplest of requests that I would make to have a conversation with him. Very quickly thereafter, once he was evaluated by the medical staff in the jail, and once he had the opportunity to dry himself out from alcohol, his entire demeanor, presentation, et cetera, changed to the extent that I had a discussion with the doctor that performed the competency evaluation, and he and I came to the same conclusion, essentially, that whatever was going on probably had as much to do with the fact that he was not on his appropriate mental health meds and he had overconsumed alcohol. He has a pronounced difficulty with alcohol. He was drinking not just a couple of drinks a day, a couple of bottles a day of hard liquor. That is not sustainable for a number of reasons, not the least of which is that it tends to create problems with your liver that confound and even work against your mental health medications if you're on any to begin with. And if you look at even the sort of watered down or sterilized version of the events in question is set forth in the report, I can assure the court the initial police report was much more bizarre in its description of Mr. Burrows' behavior in particular. Just inconceivably silly things like threatening officers with the golf club. And some of the statements that he made at the time indicated a person who was either heavily under the influence of a controlled substance, alcohol or some combination thereof, or someone having a mental health crisis, or, as we've come to determine, at least in my mind, some combination thereof. Now, what Kevin could have done was use that as a shield. He could have said, look at these, I have this terrible mental health problem and I'm not responsible for my actions, and I shouldn't be held accountable for what. He didn't do that. once he had the ability to start thinking clearly, which like I said, was within a few weeks of his stay in jail, our level of conversation and communication, I was pretty impressed and pleasantly surprised that he was able to grasp the concepts we were talking about and have an intelligent conversation. So no, I don't think he is mentally ill. No, I don't think he's incompetent. I know I have a doctor's evaluation saying he isn't, but I think you get my point as well. I do think he's taken responsibility for what occurred here, what he did. And while it's embarrassing and it's heartbreaking because it reveals a lot about his relationship with his identical twin brother and their mother, those are difficulties that are not new to this family's relationship. He grew up in the Benzie County area. His parents split up when he was relatively young and have essentially pitted everybody against each other. So conflict and chaos and trauma and stress have been a part of his relationship with his family for as long as he can remember. That led him to make some poor decisions with regard to his overconsumption of alcohol that only compounded his already existing mental health issues. Why am I telling you all of this when I know there's no such thing as diminished capacity? None of that's defensive in nature. None of that provides him with any degree of sympathy on the part of the court or anybody else. Here's why I'm telling you that, because he's a different guy today. I have said that before, and I know it's something like, the boy crying wolf, right? My client has changed, Your Honor. He's no longer the person that did these terrible things. This is one case where if I could go back and erase that section of the audio from the other presentations that I've made before this court, where I used that as an example or used that as a point of contention or point of discussion, I wish I could, because this is a good example of someone who needed an intervention. And unfortunately, he chose just about the most difficult way you can imagine to get that intervention that he sorely needed. In the intervening 191 days, he has really gotten to the point where I was speaking to him in the jail and he was able to tell me things like, yeah, I'm kind of depressed today. There's something going on. My brother had an issue, this, that, and the other thing. What I want you to know, and what Kevin wants you to know, is that he does not want you to absolve him for his involvement in this incident. He doesn't want you to feel sorry for him or say, gee whiz, maybe I should show some lenience here because the guy was having an issue. What he wants you to know is that he's addressed it. He's addressed his mental health concerns. He's had 191 days to dry out. He told me he's never, ever going to touch alcohol again. And for what it's worth, Your Honor, I believe him, because he's had an opportunity to not only look at this incident, that's one of the things that we also talked about, but look at the impact that alcohol has had on his life since he started drinking when he was 14 or 15 years old. That tells him all he needs to know about whether or not that's something that he can even reasonably entertain as a vice in his life. Of course, the answer is no. I see the guidelines, they're both intermediate. I think they're both intermediate, for whatever it's worth. I also see the recommendation, which is unfortunately unequivocal in terms of additional jail time. I would like to adamantly suggest or recommend to the court that there be no additional jail time here. He served 191 days. This guy needs an opportunity to get out, get back on his feet, and get back to work. He has work lined up already. It's not the kind of work that he was doing before. He used to be a line cook in a kitchen. which is what he really enjoys doing. But he knows the practical reality of his situation is he needs a paycheck. He needs to get out. He needs to finish up whatever is left of his disability case, and he needs to make a determination on where he's going to live and how he's going to live. And he's already made progress, at least in his own plan for those aspects of his life, which is a further illustration to me of how far he's come.
How is he going to get a job? Do you remember what he's listed on? Is for
Yeah.
his source of income?
Yeah,
What is it?
it's disability.
Okay,
Yeah,
all right.
he has a case pending right now, and he's always tried to work at least up to the limit of what he had before. For no other reason than the fact that it gives him something to look forward to.
Yeah, but there's nothing listed under employment. I don't have a letter from some employer saying, I'm gonna hire this guy. I don't know how I could make that. I've got a guy who's 40 years old, and according to here, he's never worked.
Well, that might not be entirely accurate, but I don't believe it's a significant point.
That's a significant point to me, because
I understand that.
what's a significant point to you, because you're the one who made it.
I
You tell me he's got,
understand.
yeah, you tell me he's got a job, he's never worked, and I've got no employer. And by the way, whenever I talk to community corrections or probation, they will tell me that most of the time when the defendants say they've got a job, they never have a job. But, all right, well, let's just skip that point.
Yeah,
All right.
and maybe he isn't. He's been talking to someone who's expressed an interest in hiring him. I
Okay.
put a more positive spin
Okay.
on it than that.
All right,
And he has worked in a kitchen before. I don't know if that was a formal arrangement or something along those lines. That's the kind of work he likes to do because it keeps him engaged with his thoughts and things like that. Again, I would have the court examine this for what it is. This was a terrible, terrible day in his life, and conduct that simply cannot be explained or condoned in any way, shape, or form. However, on the other side of that, based on his overall lack of criminal history, he's only got 10 points on PRVs. I think a 191-day jail sentence is more than appropriate, and he's already served that. The court would like to keep him on supervision to, again, if you have concerns about his ability to forge his own path, I think that's appropriate. He's happy to do that as well. Thank you.
thank you. By the way, Mr. Doubleton, there's one thing here I detected a little bit earlier, but I was gonna wait. Everybody's got his, the date he started using alcohol changes. It's either 13 or 14. According to CFJ 284, it's on page 7, it's 21. However, that doesn't make sense because he's 40 years old. You take, and his start date was 2002, and right now it's 2025. If you take 23, subtracted by 40, you get 17. So on that page, it says he started drinking at 21. That's not right. And unless it's wrong on CFJ 145 page 1. So just make sure you, at least on page 7, you put down 17. Got it?
Yes.
Yeah. All right, Ms. Carey, allocution.
This was a terrible day. It was a terrible day for his mother. She was terrified. I met with her, I talked with her. She was terrified. She was attacked in her home. Once she was able to get outside, he put his dog on her, who attacked her. He got a belt and put it around her neck, and she was able to do what she could to get her hand between her neck and the belt. He was terrified. The amount of liquor he drank that day and was drinking on a regular basis is astonishing. And I appreciate that he is taking responsibility for this, but when I think about what she went through that day, really hard to fathom what happened that day at his hands. And so clearly he can't drink again, ever, and shouldn't. And I hope that he's taking, told while in jail, he's been doing some counseling, and I don't know if he's been going to AA or not, but something has to change here. I am going to ask that the court follow the recommendation in giving him more jail time. I'm going to ask for at least 300 days with the credit that he has. I'm also going to ask for 24 months probation and continued no contact with the victim.
All right. Thank you. One moment. Okay. All right, Mr. Rose, you have the right to make a statement if you choose to do so. Is there anything you wish to say today, sir? I understand that you entered a no contest plea, and that's typically done for a reason. Yes. Anything you wish to say today?
Please.
Yes, sir. It's up to you. Go ahead.
I forgot to do some paper, but I have been attending AA.
I see that in the report. It's mentioned.
And I've been doing the CBT program.
Okay. Where's that out of?
Catholic Human Services.
Okay.
I've got 19 total visits, classroom work done through that. I'd like to continue that on when I get out with the opportunity. And I would also like to make a note, if I could, that my mom was bitten by a dog, sir, but it was her dog that was euthanized because of that.
Okay, what is
There's
that?
no, I'm just saying that there's not proof that it was my dog that did it.
Okay.
That's all I'd like to say.
All right. Thank you, sir.
Thank you. Actually,
Yes, sir.
there is one more thing.
Okay.
Mrs. Prosecutor, I'm not sure how to say that. She is right. I should not drink anymore. And I don't believe that I will. I know that the urge will always be there, but I'm through AA and seeking counseling, I believe that I can refrain from doing that. Thank you.
Thank you, sir. Mr. Rose has a relatively short criminal history here. This is number 5 out of 5 entries in his criminal history. And those 5 are spread out over 21 years. He began with thefts back in 2004. Then he got a drink and a driving in 2007. I don't see anything down here that suggests that he failed probation. You see that he had an act of domestic violence back in 2016, so 19 years ago. Looks like he was successfully completed probation, and that charge must have been dismissed under the section 4A, it looks like. Then he made it until he picked up a weapons charge, but here's what's important about the weapons charge. It was possession of a firearm while intoxicated. And he picks up this case. So I've got a couple different acts of violence and a couple different acts of alcohol. And some of the things I'm going to say here are that, well, somewhat to help. I've kind of highlighted a little bit. I'm not trying to be derogatory, but when I ask people or counsel if they have any corrections to the PSI, that means anything, because here's what I'm left to look at. Well, he's got no employment history, he's got disability, for the last 2 years. So since he's been 38, which means for the previous 20-some years, he never worked. I don't know. And if I don't have a letter from an employer saying I'm gonna hire him, the likelihood of me believing that he has a job lined up is 0. Then when I look here at his mental health history, we talked a little bit about today. According to this, he's got a diagnosis for schizophrenia and anxiety. And the only medication for which he's on is Ativan, a benzodiazepine, which he's mixing with alcohol. So that's not good. Apparently he's untreated for the alleged schizophrenia. Well, that's concerning to me, because I've got a person who's got a significant diagnosis with no treatment. And the only treatment he has is Ativan, which is used for anxiety as well as sleep disorders. And then this never made sense to me when I saw it. Well, that for alcoholism, he's gone on gabapentin and Norco. How is that at all related to treatment for alcoholism? That means now I've got him using Ativan, a benzodiazepine, gabapentin, which is not the same thing, but it's only recently become, I don't know if they call it a controlled substance or a monitored substance. And then you've got Norco. How does he have Norco for pain, alcoholism? I'll tell you, I can't imagine anybody getting Norco, an opiate. So it's a lot different than just skimming the surface. He never finished high school. He's never held a job. He's on 2 or 3 different medications, mixing it with alcohol, and then beats up his mother, who is 69 years of age. It doesn't say maybe a dog bit her, but it says that they sicked a dog on her, or he did, and he put a belt around her neck. Oh my gosh. Anyways, the fact that I've got a couple intermediate sanction cells on this case is worrisome. But he's got 2 felony convictions now. When they changed the language about, they mean in the legislature, regarding intermediate sanctions, they no longer said that it includes only a jail sentence. It can't even be a prison sentence. And I would have to find reasonable grounds. And when you're talking about an act of domestic violence, I don't really need to find reasonable grounds anymore. So I'm kind of at a loss here what to do. Mr. Burrows, I treat this a lot more serious than I've heard any single person. I'm not picking on anybody necessarily because they're all doing a good job. I treat this a lot more seriously than anybody else here.
Yes, sir.
Do I think you're going to go back out there and drink? Yeah. Why? You've never worked. You've got no degree. You've got no high school diploma. You have done nothing to set yourself up to let me even think. You're going to, and by the way, according to this, you drink a 1/5 of alcohol, not a 1/5 of beer, a 1/5 of hard alcohol a day. Oh my gosh.
Yes, sir.
I've got no idea how you're paying for it. First of all, you're drinking a 1/5 of alcohol a day. There's no way you're going to knock that addiction and that lifestyle at the age of 40 without something significant. Anyways, Well, the question for me is not whether or not you get out. You're not getting out today. That's certain. Time served is definitely not adequate, especially on count 2. On count 2, my question is, do I think about the way the law used to be written and think that an intermediate sanction shell should be limited to 2 a year in jail? No. Mr. Stapleton, for boot camps, do they also work with diplomas and education?
Yes, they do.
Yeah.
They have a very high success rate.
Yeah.
GED.
Yeah. So if I just put you in jail, I'm setting you up for failure. That's what I'm doing. I'm not giving you anything. You're not getting a diploma. I've got no reason to think you're going to get a job without one. And with your disability. And I've got a person who's 40 who's had a couple different drinking violations and drinks a fifth a day. Yeah, Catholic Human Services is great inside the jail. That's why we work hard to get it in there. Pay for it.
That's why, Your Honor.
Yeah.
Excuse me, I'm sorry.
It's okay.
That's why I had mentioned, I believe that I would like to continue the CBT program once.
I understand.
Really. Also, the AA, I will continue. And I think the counseling will help a lot with my drinking issues, once I can get some of the things out in the open and off my chest that lead me to drink.
Yeah.
Again, I say some of the things. I'm very sorry for what I did. I truly am. To think that I did it to my own mother is just, I don't have words for it. I have had previous employment. They're just not listed down. If you'd like, I can.
Now we're past that.
Okay.
That's why I'm saying if we're going to go through a pre-sentence investigation report, then there are changes to be made. When I ask them if there are any changes to be made, that's when they're to be made. If not, then I'm going to proceed every time I'm sentencing as if the information therein is true and accurate. Because when I ask if there needs to be any changes and there aren't any, then I'm being told that they are true and accurate. So, all right. Court sentences the defendant as follows. I really want to send you to prison. I really want to send you to prison and let you get boot camp. Because you need something solid in your life. However, you've also completed probation the couple times you were on it. The court sentenced the defendant for both counts 36 months of probation and adopts the terms or conditions that are listed on CFJ 145, pages 2 and 3. I find that those conditions are well suited for rehabilitative purposes, particularly those that deal with alcohol and controlled substances and treatment. Now, that also includes any medication for which you are not on a prescription for. All right. For count 1. The court sentences the defendant to 191 days of jail with 191 days of credit. Go about this in a slightly awkward way, but $268 state minimum fees, a $130 crime victims' right fund fee, a $300 court cost, a $500 fine, a $300 attorney fee. We had to have a DNA fee here, or was that already done? Okay.
Didn't do it to the Wexford County Sheriff, $60.
$60 payable to Wexford County Sheriff Department. Supervision fees of $30 a month or $60 a month if there's any electronic monitoring. There should not be any other fines and costs. as for count 2. The court sentences the defendant to 365 days with 191 days of jail. Mr. Brett Burrows, I'm going to explain to you the significance with that sentence. If you violate probation, and I decide to add jail or some kind of confinement to it, because I have maxed out your jail, there's only one place to go. Hoping that you change your life, get off of alcohol, start getting treatment. If you do not, I will send you to prison. And if you do, you won't get boot camp. Thank you. All right, Mr. Stapleton, have I missed anything?
Nothing.
Ms. Carey? Anything?
Maybe. Can I ask the court to hold restitution at 0
Hold it at 0?
or set it at 0?
Restitution is 0.
Yes,
Okay.
and for count 2, yes.
Yep.
Thank you.
All right, Mr. Burrows, Mr. Harrison's gonna come up and grab two copies of this one document. You're gonna place your initials on one copy. Doing so neither elects nor waives your rights. It merely acknowledges receipt of your copy of the document. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. If you choose to file a claim of right to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. The fact that I didn't have a victim impact statement here today was a big deal. And she come in and your mother come in and ask for more time. I would have, she didn't come and speak, not punishing her, but that just kind of gives me a little bit of an idea of where she's at. All right, thank you very much. We're adjourned.
Thank you.
Thank you.
Yeah.
It's the Courtroom Files Live on a Monday. I hope everybody is doing well today. I know I am. It's a beautiful day. Sun is shining, birds are chirping, and it's not 182 degrees in the desert today. You gotta love it. Let's go to Jefferson County, Texas, where Judge Stevens will undoubtedly be looking to proceed in summary.
We're talking about Antonia Barcina?
Yes, yes.
In 23 CR 2210?
Yes,
That, all right.
there was a,
Look, there is nothing on, and I'm not before.
there was another,
20 years, I only do it one way.
there was a second case.
Oh, there was another case.
Yes, this case did not get revoked. 209, it was,
Okay, this was left behind.
209 was revoked and she was given a year state jail.
Okay,
And so,
this is third degree felony, right?
right.
All right. 23 CR 2210 is called the state of Texas versus Antonia Maria Barcenas. You're Miss Barcenas?
Yes, sir.
Present, Mr. Dusler, your attorney and the state's attorney. Does the defendant waive a formal reading of the motion to revoke probation? This was filed almost a year ago now. Can we proceed in summary? In summary, this motion states that by the way, raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing, ma'am, will be the truth, the whole truth, and nothing but the truth? So help you God. Lowers. This motion states that on May 29th, 2024, in Jefferson, in this court, the Criminal District Court of Jefferson County, Texas, that you were placed on 10 years deferred or unadjudicated probation for the third degree felony of credit or debit card abuse of an elderly person. Is that true?
It counts 3, 4, and 5.
Is all that true? Okay. 3 stated you were illegally in possession of methamphetamine on or about November 11th, 2024 in violation of condition 10 of your probation order. In this case, is that true or untrue? What else was it?
4 and 5 is one of them.
Are these other cases in Chambers County pending?
No, sir, they
What
did not file them.
Huh?
They were not filed.
Okay. 4 states you failed to provide verification of performing community services hours as required by your probation order. Is that true? Are you pleading true then to allegations 3 and 4 of this motion to revoke unadjudicated probation voluntarily? Because those are true. We understand that a knowing and voluntary plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation. Your probation can be revoked. You can be found guilty and sentenced to no less than 2, no more than 10 years confinement in prison. In this case, knowing that, do you insist on pleading true today? I find you pleading true voluntarily. You understand and appreciate the consequences of pleading true. All right. What are we doing?
The agreement is to revoke that and send her to 10 years.
Why?
Wait for 10 years.
Why not just a flat time thing?
That's my understanding, that after the previous case was resolved in this court with Mr. West, that was the agreement that all parties had agreed to, but for some reason it did not get disposed of on that date. And then they sent it back to me.
Why? What's the purpose of putting on probation? How much time does she have? Good.
She's got about a year.
213 days.
What's the loss on this? Is there a
$580 was the restitution I saw on
was
those.
it paid? Where's the probation office?
He got the ones liaison, what's for?
Yeah, we need to know what the status is on the probation.
Back on October 13th, it shows that she still owed $355 on the restitution.
Is that right? Yes.
Yes.
Yes, ma'am. Are you able to pay that? When?
As soon as I get out.
You have a percentage report by any chance?
Let me see if he's got one in here.
I don't think there was, maybe a post-sentence report, there's not a pre-sentence.
I'm curious about criminal history. See, I don't see anything on the indictment about criminal history.
I didn't show any, guys, but it's been a while.
Sir?
I didn't show any issues.
Do you have to get out to get the money, or can somebody get it on your behalf to pay?
I would have to get out to get it
Why is that?
because my mom just passed away and she left me some money.
How long would it take to get it? Prior to that, you were released.
Less than a week, maybe?
Ma'am?
Less than a week, maybe, is that?
It's taking a long.
Probation officer.
This is her misdemeanor adult history, judge, just a couple things.
Anything? Do
Uh,
you have a felony conviction? Like, you know,
I don't think.
there's no one in the world should
Just
ever
these-
have to think about it.
just these two charges I show on the pre-sentence report.
Okay.
And the misdemeanors are,
This is supposed to be really important part of your life. If you're uncertain if you have a felony conviction, something is wrong here with you. You would know for sure. Nobody would know better on the planet. Okay.
Lucky for us, Judge Stevens just decided to mute there. So we're a few minutes in the Wayback Machine. Let me see if I can nudge past his silence. There we go.
Would you go back to the original plan?
All right.
10 over 10.
All right, there's a plan here that's been reached where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years. And you would be ordered to pay the restitution. All things being the same, though, on my watch, you know, the quicker you get all this done, the quicker you get off probation. Is that your understanding of the plan? If I follow this agreement, you have no right of appeal of your case then. Do you understand it? So, once again, how do you plead to allegations 3 and 4 true and correct in this motion to revoke probation? And again, you're pleading true and correct voluntarily because it is true. Let me show you what's marked here, State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney? Is everything true and correct? States Exhibit 1 tender, without objection admitted. This states if I follow this agreement, I'm about to do that. You have no right of appeal. All right. Anything further to add?
The only thing I would just ask Judge, if you want to consider something less than 10 over 10, if you wanted to do 2 over 2 or something of that nature, but again, 10 over 10 is fine. Let's
Let's
That's what we do the 10 over 10.
All right.
State, she's getting a deal.
Okay. If nothing further, I'm going to find Ms. Martinez, you have pleaded true voluntarily, knowingly, intelligently, to allegations 3 and 4 of this motion to revoke probation. And that is enough to grant this motion to revoke unadjudicated probation by a preponderance of the evidence or greater, and your probation is hereby revoked. Earlier in this case, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted during that plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this underlying offense, this 3rd-degree felony of credit or debit card abuse of a male for the person called finding you guilty beyond a reasonable doubt. You were hereby sentenced in accordance with this agreement to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That will be suspended. You will be placed on regular probation for 10 years. There will be terms and conditions of probation, which I'm about to sign, which are required of you. Make sure you do follow these terms and conditions of probation. Probation officer is going to go over these. If you fail, like I just wrote in red, your probation could be revoked. You could be found guilty and sentenced up to 10 years in prison. Also, as a condition of probation, we must pay restitution back within, how long did you say once you get out? Within 30 days from the time you are released. And that will have a lot to do with early release from probation. All right. Was it? Anything else? That is all. Thank you.
All right, let's step across the hallway to Judge West and check in on the Jefferson County Morning Fashion Show.
This is Mr. Hoffpower. This is cause number 25 DCCR 0903. Ms. Jackson is charged with abandoning or endangering a child. Janesha, okay. Ms. Jackson is charged with abandoning or endangering a child. And Mr. Lewis, what is the announcement?
Judge, I've been talking with the state about this.
We have, Judge. We need to reset, Judge, because it looks like there was another charge in here that we don't have, and I need to look into
Okay.
why it's not there, because it's the underlying or for the endangering. It's a DWI passenger with a
Oh, okay.
child passenger.
Okay, so we'll just do a normal reset. You can check
Appreciate
into
it.
that, get with Mr. Lewis once you find out. Ms. Jackson, stay in touch with Mr. Lewis. He'll let you know when you need to be back, and so y'all can visit about when he finds out before that date, okay?
Yes,
You're free to
ma'am.
go, ma'am.
Thank you.
Is Bruce Smith coming? Oh, okay. I've got yours ready now. Mr. Eckhart on Precious Eaglin. All right, again, your Precious Eaglin. And let me get this pulled
Judge, this is a plea on one and a dismissal on the other, and just because of her timing as far as medical issues, we are going to ask to waive PSI today if the court's willing to do it.
Oh, no, not on these offenses. It's required in anything above a state jail felony, and I need it for these two offices as well. So, okay, and if you'll make sure you email that attachment to them as well. All right, will she waive the formal reading of the indictment?
We will.
And are you pleading guilty freely and voluntarily? And because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Eckhart? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 7-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. There would also be a dismissal and cause number 25 DCCR 0318 as part of that agreement. Is that your understanding? Speak up, please.
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes,
State tenders number 1.
no objection.
It's admitted. Is there any evidence that Ms. Eaglin is not competent?
No objection.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's sitting at that desk right over there. All right, we'll see y'all back at sentencing.
Thank you, Your Honor.
Thank you. Thank you, Mr. Eckhart. Oh, look at you. Good job. Did you have something? I know it did. Mr. Smith, are you ready on Brian Verrier?
Yes, Your Honor.
Good morning. Morning, Mr. Smith.
Hi, Judge.
How are you?
I'm having one of those stupid flare-ups.
Uh-oh.
I'm having surgery tomorrow also.
I knew that was coming. Good morning. Are you Brian? Is it Verrier?
Yes, ma'am.
And Mr. Verrier is charged in cause number 24 DCCR 0128 with placing a serial number with intent to change identity. And what is the announcement, Mr. Smith?
Yeah, this is definitely gonna be a plea. We're asking that you put it in January. Just, he needs some additional time to finish paying off his attorney fee.
Any issue?
No issues that I'm aware of, Your Honor. I don't have a problem with the reset.
When is the, when do you anticipate being back and ready to go, Mr. Smith? Because this has been going on since April, so.
Oh, I'll be ready 1st January.
Okay, all right, we'll reset it to the plea docket. Make sure you stay in touch with Mr. Smith. It'll be the first part of January, and we'll get that plea taken care of. All right, you're free to go.
Thank you, Your Honor.
And then Fabian Hall, you're free to go, sir. Good morning. Are you Fabian Hall? And Mr. Hall is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
No, it's
We have reached an agreement. It's the same announcement. I'd like to do it first part of January. So we can finish paying him off his attorney fees.
This will be the final reset. You've been on it since April again, so whatever you need to take care of, we'll take care of it. It will be on the plea docket, and we'll take care of it on that day. All right? Thank you. Free to go.
Barbara, I don't remember if I thanked you for the gifted membership, so thank you for that. If I have thanked you, thank you again. Real quick before we go to the next court, you know, the Courtroom Files Live is not only a YouTube show, we are also on Rumble and we are on X, and as of Friday, we are also now on Kick. So if any of you out there are on Kick, you could really help us out by going over there and following the show over there and help us build that out. The initial reaction over there has been good, so I'm kind of excited about what we've going on Kick. So yeah, help us out. Let's go to Florida. Wade Mercer, first appearances.
Others in the courtroom, ma'am. You're here for first appearance accused of one count of driving under the influence. Ms. Robinson, there is probable cause in the complaint, ma'am. I'm going to appoint the public defender's officer to represent you. I'm going to ask that you listen to Mr. McDaniel, and we'll see where we go this morning. Mr. McDaniel.
Your Honor, I spoke with Ms. Robinson. At this point, she's going to go ahead and accept the offer and plead no contest, adjudicate guilty to DUI, 11 months, 29 days probation, 50 hours of community service, DUI school, AA counseling as required by, as may be required by probation. And she signed her plea waiver form, waiving the right to a jury trial and call witnesses. And this will resolve this case this morning.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Thank you. So Ms. Robinson, did you hear that agreement, ma'am?
Yes, sir.
Ms. Robinson, do you have any questions about that agreement?
No, sir.
And Ms. Robinson, is that the plea that you would like to enter?
Yes, sir.
Ms. Robinson, I'm going to accept your plea of no contest to the charge of driving under the influence. Judge you guilty of that offense, ma'am. Sentence you to 11 months and 29 days probation, $1,078 court cost and fine, successfully complete substance abuse counseling, successfully do 50 hours of public service work. Substance abuse counseling will be once per week for at least 12 classes. But if you register for DUI school within 60 days, they're going to make you go to 16 hours of counseling sessions for DUI school. So that can count towards your counseling total, ma'am. I do recommend the minimum driver's license suspension. And Ms. Robinson, it's possible to get off probation early. Ms. Robinson, in order to do that, you've got to do half your probation. In your case, that's 6 months, have no violations and get everything done. So as long as you do that with no violations, get everything paid, all the community service done, ma'am, there's a good chance you'll get off probation early. Ms. Robinson, they're going to get you dressed in your regular clothes. They're going to let you use the phone if you need to set up transportation, which I'm going to ask your mother about in just a second. Then they're going to bring you to the courthouse. When you get to the courthouse, you'll meet with the probation officer, Ms. Robinson. After they meet with you and answer any questions you have, you'll be free to go. So to her mother in the courtroom, ma'am, are you going to be able to pick her up? Your mother says she's got transportation covered for you. So roughly 30 to 45 minutes in the probation office downstairs on the east side of the courthouse.
Okay.
Ms. Robinson, go ahead. Yes, ma'am.
I'm sorry. Is there any way that I can get like a?
That's DMV that does hardships.
I was gonna ask if I could get a license to drive to work, but he said I gotta ask the DMV.
When you get here, Mr. Goodson will explain that to you. There's a process. Once you've pled, you have no license for a certain period of Mr. Goodson. There was a breathalyzer, but it was zero. It's believed to be some substance other than alcohol. So there was no breathalyzer. Well, there's no over 0.08 breathalyzer. It was not a refusal. Correct. Can you hear Mr. Goodson, our probation officer, ma'am?
No.
Okay, I'm going to ask him to step in front of the microphone. He's the most knowledgeable person at the courthouse about driver's license issues. So listen to Mr. Goodson, and we'll see if this answers your question.
My understanding of the law, Ms. Robinson, is because you pled guilty to the DUI that you will lose your license in the state of Florida for a period of 6 months. That's an administrative suspension placed upon you by the Department of Motor Vehicles. You are eligible to apply for a business permit license after 60 days. In order to receive that business permit license, you would have to be enrolled in DUI school within 60 days. You don't have to have it completed, but you do have to show proof of enrollment prior to applying for the business permit license.
So if you apply, if you enroll in the DUI school, then you apply for your business permit. You're still going to have the 60-day downtime, correct? But you would be eligible potentially for a business license after 60 days. Knowing all of that,
Do you still want to?
do you still want to end this plea, Ms. Robinson, or do you want to wait? Your other option, I'm sure Mr. McDaniels explained it to you. He's probably talking to you now about it, so I'll let him do that in private.
I didn't see anything.
There is a ticket.
There is a ticket.
But if she doesn't plea and she takes the conditional release with no prior DUIs, there's a system where she can enroll in DUI school within 10 days and then not have the suspension. Well, she'll have the suspension still. It's just she'll have the work permit before it kicks in. So let Mr. Goodson explain the other option you have. Mr. McDaniel may have explained this already. I just want to make sure that we're all on the same page. So listen to Mr. Goodson.
My understanding of the law, Judge, is, of course, the officer didn't mark the box eligible for permit, but I assume that. So you think they sent the blood off? That's the only question.
Blood has been sent off, yeah.
Yeah, they was sent
They
Or
never
urine
took
sample has
blood.
been sent.
the urine sample.
So I don't know if she would be eligible for the 10 days. I don't know that her license would be suspended today.
She'd have 10 days from the ticket to contest the license suspension.
I know that, but my question is, because they requesting a urine sample or blood, does that affect my personal belief, and I don't know the exact answer, is that she would be eligible to apply for the business permit within this 10-day period. In order to do that, there's several things that has to be done. Number one, she has to show proof of enrollment in DUI school, and that's $445 to enroll in level 1 DUI school. She would have to enroll in DUI school within 10 days. She would have to fill out the affidavit that I have that's supplied to me by the Driver Improvement Bureau. So she would have to email a copy of proof of enrollment to the DUI school, a copy of the ticket, and fill out the affidavit to apply for the business permit. My understanding of the law in the state of Florida is your first time offense that you can apply for a business permit and you don't have the dead time.
So if you plea, your license suspension today would be because of you entering a plea. Because you didn't blow over .08, you don't have a license suspension right now, right, Mr. Goodson? But when you enter that plea, you will get a license suspension effective immediately. So what Mr. Goodson is saying is that if you wish to wait, if this is going to cost you your job, we can give you a court date. Mr. McDaniel's probably explained to you what a conditional release is. If not, I will. We can give you a conditional release and court date. That gives you several weeks to try to get a business license. And if you do that, and if it works, you'll still have your license be suspended, but you'll have a business license, and the 60-day downtime won't apply to you. But if you plead today, the 60-day downtime will apply. It's entirely up to you. I just want you to fully understand your options.
Well, can I still get the same probation offer and all that? Or?
As long as you don't get in trouble between now and your court date, the offer is going to be the same. Is that correct, Mr. Mitchell?
Yes, Your Honor.
Yeah, that Mr. Mitchell doesn't change the offer unless there's a change. If you get charged with another DUI between now and your court date, yeah, the offer is going to change dramatically. But as long as you stay out of trouble and we don't find out that you have a criminal history, which we don't see anything, then the offer is going to be the same. Even when the blood or urine sample comes back, she won't get a license suspension because of that, because it's not going to be quantifiable. You don't get a license suspension for having, say it's some kind of prescription medication in your blood. You get suspended for the conviction. The exception to that is alcohol, and her alcohol was 0.
Correct.
Mr. McDaniel?
So she's going to go ahead and just take the conditional release, Your Honor.
Okay. Is that what you want to do, Ms. Robinson?
Yes, sir.
So what that means, I'm talking to your mother now, is she's going to try to see if she can get her work permit before entering a plea. She may come to court and decide not to enter a plea. That's okay too. But she'll get the same offer she was made today, which was a standard first offender probation. So hopefully she can get it situated. She enrolls in the DUI school. She fills out the form Mr. Goodson's talking about. She gets her work permit issued, and it'll be effective. So that when she enters the plea, she won't have a 60-day downtime of no license at all. So what we're going to do is grant you a conditional release. You'll have the standard conditions of the conditional release, plus you'll have a condition of no alcohol, which is every conditional release. You're also going to give you a notice for your court date, Miss Robinson, and that'd be January 5th at 9 a.m. will be your court date. Do you have any questions, Miss Robinson?
No, sir.
Ma'am, in the courtroom, she's still going to be picked up, still going to be roughly half hour to 45 minutes. And they'll give her that written court date when she's here. She will not get mailed a copy. They'll put it in her hand before she leaves. Any questions you have, ma'am? Ms. Robinson, wish you the best. We'll see you in January, okay?
Thank you.
Yes, ma'am. Thank you for coming, ma'am. And then we have only one other case this morning, and that's James Griffin.
And the notice for this one will be the 6th.
Mr. Griffin, good morning. Mr. Griffin, you're here because you've been accused of one count of burglary of a dwelling and one count of petty theft. Mr. Griffin, there is probable cause for both charges. Mr. Griffin, I'm going to listen to the attorneys and then I'm going to address your bond. I have looked at your criminal history, which shows nothing in 25 years or so, at least, and a couple of charges, old charges before then. Mr. Griffin, listen to the attorneys, and then we're going to see where we go as far as bond and so forth. Mr. McDaniel, anything on behalf of Mr. Griffin?
Nothing. We just asked to consider conditional release.
Mr. Mitchell.
What's his criminal history look like before the 25 years?
He's got like 3 total charges. What his criminal history reflects is a 1976 contempt of court. I was 5 years old. 1989 family neglect. This doesn't show disposition. It's just a charge. Domestic violence in 98 and 1998 dealing in stolen property. And that's the last thing on the criminal history. And that one was actually dismissed. It does show that. So nothing in 27 years of any kind. And the last thing 27 years ago was dismissed.
I mean, we'll leave it up to the court if you want to grant conditional release, but if you go with a monetary bond, we're okay with something lower than what's usual for a 3rd-degree felony.
I don't know that I'm going to grant a conditional release when he's allegedly found in someone else's apartment. The complaint alleges there may be some memory issues, but that's very concerning. Mr. Griffin, the alleged victim allegedly lives at apartment 9 on Clinton Street. Is that Chipola Apartments or is that a small apartment complex?
It's Chipola Apartments. It's Chipola Apartments, Your Honor. This is a issue with his, possibly cognitive decline.
So what apartment are you in, Mr. Griffin?
I'm in apartment 3.
So my concern is allegedly he's caught inside another same apartment complex inside their apartment. And then they allegedly found stuff missing and then found it in his apartment. So the criminal history is very good, but I'm concerned that I just don't know.
Well, we'll just ask for a reasonable bond under those circumstances and no contact with that apartment's unit. Understanding he lives at the complex, so we just request that unit.
Mr. McDaniel?
What stuff did they find in his apartment, just out of curiosity?
It was not significant monetary value, but what he supposedly stolen was some Hey Dude shoes, a phone charger, SpongeBob slippers, a set of 10-pound dumbbells, and a pink notebook containing personal information. And then it says several of those items were recovered. It doesn't say which one specifically. It implies that all of them were recovered. When they found him in the apartment, he allegedly had a black bag in his possession, and he gave permission to search his apartment, supposedly, and the black bag was found in the closet with those items in it. And then he told them, according to the complaint, told them he didn't remember going over there.
I was just asked for, I think there's some cotton too behind here, Your Honor, but we just asked for conditional release.
Mr. Griffin, do you understand if I did grant you a conditional release, you cannot have anything, you can't go to that apartment at all. Do you understand that?
Yes, sir. Yes, sir.
And let me clarify, you can't go to that apartment number. You can live in that apartment building. You just can't go to the other person's apartment, which is apartment 9. You can't go there at all. And you can have no contact with the person who lives there. In other words, if you see them on the elevator, you don't get on the elevator, you take a different elevator, you wait till another elevator comes, or you take the stairs, you don't talk to them, you don't see them, you don't have any communication with them. Do you understand all of that, Mr. Griffin?
Yes, sir.
Are you willing to follow those rules?
Yes, sir.
You remember those rules?
Yes, sir.
You sure?
Mm-hmm.
Okay.
Mr. Griffin, do you know what happens if you do have contact with her, or if you're caught going to that apartment again? Do you understand what would happen?
Yes, sir.
Well, tell me, what would happen?
I'd go to jail.
And you understand if that happened, you're right, you'd go to jail, but you wouldn't get out. You would have no bond, because I have no other way to protect that person's right to keep you out of their apartment other than making sure that you don't go, which the jail's the only way I can make sure you don't go. So you would be in jail with no bond. You understand that?
Yes, sir.
Okay. And are you willing to follow the rules of conditional release if I grant you one?
Yes, sir.
Do you have any questions about those rules?
No, sir.
Mr. Mitchell, anything else from the state?
No, Your Honor.
Mr. Goodson?
Judge, I know Mr. Griffin. He's the gentleman that we've seen him walk around here for the last 30 years. Mr. Griffin, do you have a phone?
Yes, sir.
He does. Okay. Thank you.
Okay, Mr. Griffin, I'm gonna grant you a conditional release because you haven't been in trouble in 25 plus years, 30 plus years, actually, since you've had a conviction of any kind. But Mr. Griffin, I need you to understand the importance of what I'm telling you. You can have no contact at all with that person, the lady that lives in that apartment, and you cannot go to that apartment at all. Do you understand that?
Yes, sir.
Are the apartments on the same floor?
Well, I was kicked out of Chipotle Apartments. I'm renting a house there behind Firestone.
Okay, well, that makes it easy then. You cannot go to that apartment complex at all. Do you have any reason to be in that apartment complex?
Yes, sir.
Do you have any reason to be there? Do you have any family or friends that live there?
Well, I have my brother that helps me.
Okay, do you understand that if you accept this conditional release, you cannot go to Chipotle Apartments at all? Do you understand that?
Yes, sir.
If you get caught going on their property, that will violate your release. Do you understand that, Mr. Griffin?
Yeah, I live in the Gilbert house, across the street. That big old house is condemned.
Why do you have the?
While they're muted, chat, check me. Did I just hear right? Did he just say he's living in a condemned house now? I swear that's what I heard him say.
Judge, I don't know if I believe what he's telling me, but I mean, he says he's got a house that he rents for $50 a month or something.
$450.
Oh, $450 a month, and so no contact with that apartment complex. But
let me ask about this house. Where's this house at, Mr. Griffin?
It's behind Firestone's old Gilbert house.
So you get to it off of Green Street, or do you get to it off of 90?
It's behind Firestone. It's up there close to the church.
He says
the
he don't have
Methodist
an
church.
apartment. He says he don't have an apartment. I don't know how they could have been into an apartment and got the stuff out. If
Well, they
you don't
went
recall letting them into your apartment.
Police went in there. Yeah, I had to unlock the door.
You had to, so you were living there then.
Huh?
You had to unlock the door. You were. All right, that's fine, Your Honor. Just no contact with the apartment complex.
I wish the officer had told us where they found the bag and how they got in there. If he says he doesn't live there. It says.
I think he said, he clarifies it to me, I think a little bit, and says they were at the Gibbs apartment.
Yep, it's Chipotle apartment. I was kicked out of there.
But
it says voluntary
He has-
consent into a search of his residence.
He has dementia,
Don't
Your
tell
Honor,
us where.
short-term dementia, so he's telling me he lives in a different apartment complex, and I don't know, I mean, he clearly has dementia issues, he's got short-term memory loss, and,
When did you leave? When did you stop living at Chipotle Apartments, Mr. Griffin? How long has that been?
It's about 6 months ago. I got
Okay, so
kicked out.
you have no business at Chipotle Apartments, correct?
I can't go there either.
Okay, so you don't need to be over there.
Don't need to be over there either.
Don't need to be over there.
No, I
Over
don't
there, either. What do you mean when you say either? Where are you talking about? Over where?
I can't remember what.
Okay, yeah, I can't grant a conditional release given I'm concerned he doesn't have the ability to. Mr. McDaniel, turn the speaker back on so I can finish this. I'm concerned he doesn't have the ability to understand the terms of a conditional release and therefore may not comply with them. Instead of doing that, I'm gonna set him a bond of $2,500. Mr. McDaniel, if you find out some additional information that may help us, there's friends or family that can help with the situation, I certainly would consider a conditional release then, but I'm not gonna grant a conditional release with a concern that he's gonna violate and then go back in this person's apartment. He's got 2 charges, so we're gonna set the bond at $1,250 each, total bond of $2,500, no contact with Chipotle Apartments at all, and no contact with the alleged victim. Mr. Griffin, you'll get a chance to use the phone in just a few minutes, sir. Do you have any questions?
Well, I'm on disability. I don't know if I can pay. I don't make but $1,200 a month. I don't know if I can pay that.
I understand.
So, Mr. McDaniel, I know that you end up doing social work a lot of times, but if you find other options that give me some other option, I certainly will consider it, okay?
Yes, Your Honor.
Thank you.
Yeah.
I don't know how that would help us, though.
It's still a felony, so he needs to get the notice for the 6th.
Yeah, we do need to give him a notice for January 6th and also get life management do an evaluation, please, Corporal, when they can do one. Hopefully they can do it today or tomorrow if you're still
Come to
there.
my apartment.
Yes, sir.
Thank you.
Okay, I just dropped a poll. Do you agree with Mercer's decision on conditional
So I
release
said
for this defendant? Let me know what you
2,500
think.
Yeah. 1,250 each count.
No contact with Chipotle Apartments nor alleged victim.
So I just received
Just a second. Is this the thing you want to talk to after we got through?
no, this is relating to Mr. Griffin.
Okay.
Just some extra information that was given to me by Captain Scarborough with the MPD. He says that Mr. Griffin lives at Clinton Street Apartments. He is trespassed from Chipotle Apartments where he was evicted.
So the resident, the complaint lists Chipotle Apartments as his residence. So why would they list Chipotle Apartments if he doesn't live there? Under the defendant's residence,
Recently evicted.
6 months is what he said. They give his address as 4381 Clinton Street, which is Chipotle Apartments. So if he doesn't live there, why did they, that's what's causing me confusion. I still don't understand.
That's what caused me confusion.
So I think the officer may have put the wrong address for him, may have put an old address instead of his current address. So when they went and got the black bag, it wasn't at Chipotle Apartments. I'm guessing it was at his other place, but either way, he's got a bond and we'll see if he or his friends or family can post it. Mr. McDaniel, I think Mr. Mitchell has some scheduling issues to talk about off Zoom and YouTube, which.
All right, they're wrapping that up. Yeah, sad situation. Hopefully they can get something sorted for this guy. It looks like everybody in the poll feels that Mercer made the right decision on holding off on conditional release. I would tend to agree with all of you. It doesn't seem like the wisest move here. Let's head back up to Michigan. We'll check back in with Judge Dad.
That's on mute.
Your name?
Robert Lewis Thornton. I took your plea to the violations, fair to clear all warrants by August 25th and fair to pay fines and costs for 60. Declared as warrants.
I think they're still no stuff.
Why isn't he taking steps? Is he gonna make me put him in jail here or what? Why isn't he taking any steps?
He's got financial issues. He had a work interruption.
Where does he work? Mr. Thornton, I need to see your, sir, I need to see your face, not the ceiling, please.
I'm a commercial painter at the company All Face Painting. This is what we discussed the last adjournment that I had in regards to my hours declining the seasonal process.
Your name, Ms. O'Donnell? What do you have to say? I didn't let you finish. Go ahead. Did you want to say something?
Judge, as far as I think the balance was 470, you said 460, but somewhere thereabout.
It's 470 on here.
Indicates he could pay $200 Thursday, and he could have the whole balance paid by July or by January 30th.
I'm worried about him not taking care of his warrants.
Judge, I think he got sentenced July of 25 for 12 months, so I think he still have him.
I know, but I gave him until August 25th.
Well, that was
to clear all warrants.
And that's why he pled the violation in November. Still has some financial difficulties when he goes to each place. I think there's 4 warrants out, and he wants to have money with him when he goes to each one. So I think he's trying to save up and get a payment plan for here. So we're asking that he be allowed a payment plan and to continue on probation.
And you said he could pay 200 today?
200 Thursday.
You got to take care of your warrants, Mr. Thornton.
I understand. I literally, the month that you gave me prior to our last actual court date, I've only worked 11 days out of that time, and 4 days out of that was the longest days prior. So I literally had nothing coming in for real. The only thing I was able to even get myself was a new pair of boots. So besides that, I was putting money up to have in order to pay on one of the fees, and I did take care of the one that I could at the time. But going down into the week again, I have to pay for rides and make sure I get back and forth to and from my job.
If I could.
Yeah.
For him, it's always been money with Robert. That's always been the issue. Everything else that he could get done without that, he's gotten done. He's been compliant on. He shows up to appointments. All 8 hours of community service are done. Days in the court work program are done. It's just always been an issue again. His transportation and money for him. Again, we do still have some time, and he's concerned with all those warrants he's got to get on.
Graduated, right?
No, sir. I've had 4 high school fires, each one, and I've been adopted since I was younger.
4 high school fires, did you say?
Yes. Initially, every year I was supposed to start high school, I had a fire happen. One regarding an issue with someone being in a family flat underneath me. One was an electrical fire. One, my little brother tried to cook something and burnt the house, and my mother was away during one time in our house, so we came back to it on fire. And I was too old to go to a high school. When I did try to go to a high school, I went to Old Redford. They kicked me out within the first month because I was too old and I was getting the attention of the younger students there. So
okay, this is what I'm going to do. You pay $200 today. You said you can pay the rest
Thursday.
Okay. 200 by, we'll just say the 12th. And then the balance, you said, I thought by January 6th?
January 31st.
January 31st. And balance by January 31. You're to clear all warrants by January 31. Are you going to say, or you're going to serve 2 days on the court work program and pay all fees associated with that? Do you understand that?
Work court date and before the 31st.
Listen to me. Listen, I'm really not going to do anything except extend your time to clear your warrants until January 31. But if you don't clear them by then, you're going to automatically be scheduled to do 2 days on the court work program and pay your fees for that. You're going to pay $200 by December 12th and the balance on this by just January 31 of 26. Do you understand that?
Yes, sir.
You got to take care of those warrants. That's what I'll do. I'm going light, but you're gonna have to have those warrants cleared by then. I'm giving you essentially 5 extra months. Okay? I wish you well. Good luck to you. Thank you very much. Have a great day.
You too.
Thanks. All right, let's find this Miller case. Okay. All right. Terrion Quandell Nathaniel Miller, 25B7169042. All right, counsel, your appearance.
Good morning, Your Honor. For the record, Sterling Coleman, P43321 on behalf of Terrion Miller.
Your name, sir?
Terrion Quandell Nathaniel Miller.
Detective, your name?
Good morning, Your Honor. Detective Crystal Tulaz, Brownstown Police Department.
So we have a preliminary exam scheduled for tomorrow, right? And then, but this is going to be a plea of false pretenses under count 12. 200 or more, but less than 1,000, correct? Is that right, Mr. Coleman?
That's correct. Yes, that's our understanding, Judge.
Is that what you want to do, sir, is plead the count 12, false pretenses, 200 or more, but less than 1,000?
Yes, that's correct.
You understand if you do that you are subject to up to 1 year in jail on this. And if you do that, I'm also going to dismiss counts 1 through 11 from the prosecutor's office. That's what they presented. That's what they want to do. Do you understand that?
Yes, sir.
And, all right. Now, you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or trial by jury. At a trial, you have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, to testify or remain silent. Again, if you remain silent, that silence would not be held against you. If you plead guilty, you're giving up all those rights. You're waiving the presumption of innocence. You're waiving your right to a trial. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. Do you understand that?
Yes, sir, I do.
No, knowing all that, you still wish to plead guilty to this count?
Yes, that's correct.
To count 12, false pretenses, 200 or more, but less than $1,000. How do you wish to plead?
Plead guilty.
On December 29, 22, were you in the Kroger parking lot at 23849 West Road in the township of Brownstown?
Yes, I was.
What did you do that makes you guilty of false pretenses, 200 or more, but less than 1,000?
Judge, if I may add to the voir dire my client.
Yeah, I mean, yeah, you can tell he doesn't want to say anything, but go ahead.
Well,
You can ask him questions.
Because it has been some time, and there was some. Mr. Miller, did you?
You can go ahead.
Did you?
Ask him.
In combination with Brandon Flowers, did you get a PlayStation using fake money from somebody at that parking lot? You and Brandon got a PlayStation using fake money, yes or no? Yes.
What? You can't answer for.
I know, Judge. I'm sorry.
Come on. Did you do this or not? If you didn't, we'll go to exam.
I
It's
did.
okay.
I don't know.
It's the United States. It's all right. If you didn't do anything wrong, I don't want you to plead to anything.
No, I did. I don't know about nobody else doing it. I did it for sure, though.
Well, talk to me. Get closer to this and answer our questions, please. Did you provide counterfeit money to somebody in the parking lot to acquire a PlayStation? And that somebody would have been a Jarrett Bucarelli.
Yes, that's correct.
How much did you give Mr. Bucarelli?
I like 4 or 5. 4 or 5.
4 or 5 what?
100.
And you took the PlayStation then, true?
Yes, that's correct.
Detective, can you tell me, was the PlayStation recovered? Is there going to be restitution owing here?
The PlayStation was not recovered. I did reach out to the victim. I haven't heard back on whether or not Mr. Flowers made restitution. I don't know if restitution has been made.
All right, are you on probation or parole right now?
He's in custody
Yeah, how long is he in custody, Mr. Coleman?
at least until February, but I believe he's been flopped.
All right. Do you know how long you're in custody until, Mr. Miller?
I'm trying to see if I can get parole. This case really messed up my parole, so I'm gonna see if the parole
Okay.
board.
Listen, were you on probation or parole back in December of 22?
22.
It's 3 years ago now.
No.
Anybody
I'm
forced you to plead guilty or promise you anything to induce you to plead guilty other than a dismissal of counts 1 through 11?
no, sir.
All right, I'm going to accept the plea to false pretense, 200 or more, but less than 1,000. Counsel, they wrote down here, time served with any restitution if applicable, plea by supervisor. Does he have a really horrible record?
No, he does have high to contacts, and he's there under.
Here's what I've got to do. Let me interrupt you. I'm sorry. I'm still going to order a PSI. We have to notify the victim. So I don't care if you appear by Zoom next time. We'll set a sentencing date out a month, and I'll let probation come and interview him now on Zoom. We'll notify the victim, and then everybody will be happy. But you got to try to come up with that money for the restitution, or else. I mean, they're spelling that out. Time served with any restitution if applicable, plea by supervisor. So you're going to have to come up with the restitution amount, sir. Give me a date, Lisa, in let's do it well after the holidays. Maybe we could do it on a Tuesday afternoon in January, I suppose.
January 13th at 1 o'clock.
Is that good with you,
That's
counsel?
fine.
January
That's fine.
13th at 1 p.m. We'll notify the victim. They're going to come on there and interview you. Make sure you take it over there and tell them that, John, please.
Okay.
And then we'll go from there, okay?
Judge, will it be on Zoom or do I need to be there in person?
No, you can come on. So he's going to be on Zoom. I'm fine with that. I'm fine with you being on Zoom.
Thank you very much, Your Honor. Everybody have a good holiday.
Good luck on your wife tomorrow. I hope everything works out for you, or whenever that was scheduled. It's coming up.
Last week, but we're doing fine. Thank you so much, Judge.
Well, I'm glad to hear that. Merry Christmas to you. Good luck, sir.
Likewise.
Stay right there. They're going to come and talk to you, okay?
Everybody stay safe. Have a good holiday.
You too. All right.
All right, let's head back down to Texas, where in Judge West's court, it looks like Snoopy is making a guest appearance now. What a weird day.
To revoke his unadjudicated probation, and then there's a new offense that's been indicted. And Mr. Coleman, I had read that and was reminded once I read your motion and the request in your motion with regard to there was some money that was found and that has been taken from that the last arrest and indictment. And what Mr. Coleman is asking is that I order as a condition of Mr. Green's probation that he go to the safety facility for treatment and that he be ordered to pay, which I can do, that amount from that money, and the state would be willing to forfeit the forfeiture, for lack of a better word. Here's where I am. What I think the best way for me to handle this is to go through the motions, get pleas of true or not true to those motions. I do what I do on the motions. If I'm inclined to continue him on probation, and a condition of that becomes safety, then I would definitely entertain what that motion is, but without an updated pre-sentence report and more information about the allegations and how he pleads to them, and if we have to have a sentencing hearing and all those kinds of things, I think I need to do it in this order. So what I'd like to do is go through those motions today, and we can just reset it for sentencing without any agreement. Is that?
Well, this time, Judge, I can tell the court he'd have to plead not true. The basis of the new offense, probable cause search of the car, was a canine search. After reviewing the evidence, it's pretty clear to me that it is definitely a bad canine search. However, I cannot argue that merits of that until I do canine discovery. It's not common for the handler to turn over their handler records to the DA's office, so the DA's office does not have those records. So I did notify the state last week that that's what I thought after looking at the discoveries, that I would need to request that. So that's what I would need to do.
Sure.
Even for. motion
For a
for
hearing on
I
this,
would
because
need-
those are the only
It's
allegations.
the only allegations of these new offenses.
So let's go through the motions. What I'll do is set that hearing out a little longer than normal to give you some time to get that information. And then if for some reason these allegations are untrue or can't be proved true, or the state has an issue as well, once you guys get into this, then it would just be a matter of if there's other items, things going on with probation through administrative hearings, through testimony of the probation officer that would lend to any type of treatment. They're not alleged in these, so that wouldn't necessarily be a revocation, but that could be additional conditions based on other things that go into it, even if those cases, obviously the level of proof for me is different in a motion to revoke than it is in a trial. So let's at least get this done. That gets us with an updated pre-sentence report getting started. You guys can work on the K-9 issue, and then we'll come back and see where we are for a hearing. Okay? So, Mr. Green, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. And will he waive the formal reading of both motions? Mr. Green, in cause number 23, DCCR 1502, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 18th of 2024 for the offense of possession of a prohibited weapon, and that was a 5-year deferred probation. Is that correct? These are the same two. I need the I need 24 DCCR 1320. Yes, ma'am. Please. I can probably get to it, but give me just a second.
Watching it dry is way better than painting.
Agreed. All right, in cause number 24, DCCR 1320, I also have a motion to revoke your unadjudicated probation. This shows that you were placed on probation October 28th of 2024 for the offense of possession of marijuana, a third-degree felony, and that was a 5-year deferred probation. Is that also correct? Each of these motions allege that you violated your probation. Count 1 alleges in each case that you committed the new offense of money laundering between $2,500 and $30,000 on June 24th of 2025 in Jefferson County. And is that true or not true? Count 2 in each case alleges that you committed the offense of wrong, fictitious, altered, or obstructed license plate March 3rd of 2025. And is that true or not true? All right, then I'm going to have enter pleas of not true to counts 1 and 2 in each of those cases for you. We will reset the case for a sentencing hearing. I'll get probation to do an updated report. We'll set aside some time for these. Mr. Coleman, looks like these are 2 separate alleged offenses, and so I would guess you would have a couple of different officers.
It's the same transaction.
Well, they've got different office dates. Yeah.
I've got a March 3rd for the fictitious license plate thing, and then a June 24th.
I'll double check the dates.
No, it don't have to be with the money. You don't have to do the same. Yeah, it's the
I'll
same
double
day.
check the dates, and I'll mean if it's.
Well, or just you can do a motion to modify the date.
It should be the same. It's the same transaction.
Okay, so then it shouldn't be, well, maybe an hour on a regular docket day, and we'll see where we are, at that time. Now, obviously, at that time, if you anticipate there being more evidence than an hour with regard to the search and all of that, let me know, and we can set it for a different date, but we'll, at this point, we'll put it just on a regular docket date, but at 11.
It probably would be fine for now.
Okay, all right.
I think the real question is, how long does it take the handler to retrieve the records and get it to the state? That's gonna be
Right, I know that's taken some time, and if there's anything that you need me to do, to help out with that, just let me know. Okay, thanks, you're free to go.
Thank you, Judge.
It's the D.O. Single G, Snoopy Dog, making a guest appearance here on the Courtroom Files Live on a Monday. Good to have you all here. Step across the hallway, go back to Judge Stevens.
Verified of that before, saying, there he is. It's right where it said. Yeah. I mean, you can verify that. Something wrong. It's above my pay grade and knowledge, sir. I don't feel like I need to. 25 CR 1219 is now called Ryan Marshall Champagne. That's you? Is there a junior? Yes, sir. And is your father still alive? Yes. Okay, so. All right, so we don't want to get this mistaken. Do we want to agree to an amendment to the name, including Ryan Marshall Champagne Jr.?
Yes, sir.
So that his father is not.
Move so to amend.
Any objection?
No objection.
Thank you, sir. His name is amended, made corrected in the indictment, in the caption, as well as in the body of the indictment. So granted by the parties upon in agreement. God bless you over there.
I'm looking just to think money is
Here. All right, in this indictment, 25 CR 1219, handed up on September 10th of this year. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about August 10th, 2025 in Jefferson County, Texas, you committed the state felony of burglary of a building. Do you understand what you were charged with? Yes? Yes, sir. Wrong. Okay. If convicted of a state jail felony such as this, you face a term of not less than 180 days nor more than 2 years confinement in the state jail. A fine of $10,000 can be assessed. Do you understand? Yes, sir. An agreement has been reached between the parties. You would be pleading guilty, found guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years. There would be terms and conditions of probation, which are normal and customary. I see restitution. What is restitution in this case? $450. Is that right?
Yes, sir.
Is this your understanding of the agreement? Yes, sir. And this is $450 to the plaintiff named in the indictment.
That's correct, sir.
If I follow this agreement, you have no appeal of your case. Do you understand? Yes, sir. Have you pleaded this, sir, guilty or not guilty? Guilty. Are you pleading guilty voluntarily? Yes, sir. On your own free will? Yes, sir, I am. And because you are guilty? Yes, sir. Show you what's the state's exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct? Yes. State's exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, the state's you are mentally competent, even if your guilty plea is freely and voluntarily made. You know what you've been charged with, the indictment's been read, and you were guilty of the crime charged and any lesser included offenses. So you were giving up your rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
States Exhibit 1, part of the record for all purposes. Pre-sentence report.
Yes, sir.
When are you going to be able, when you are released, to pay how long will it take you to pay this restitution? $450, sir? Because I want to pay back as soon as possible. You will be rewarded. How about how long?
2 weeks.
No, I'll give you 6 weeks. Okay? All right. I'm going to find you guilty voluntarily. You were mentally competent to do so. You understand and appreciate consequences of pleading guilty. There's enough evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony of burglary of the building. I am following this agreement. If I sentenced to confinement in the state jail for 2 years, that is suspended. You are placed on regular probation for 5 years. There will be terms and conditions of probation, normal and customary for this type of offense. This will include, as a condition of probation, you must pay restitution back to the complainant on this indictment in the amount of $450. That must be paid back within 6 weeks of your release. Do you understand what has happened today, sir?
Yes, sir.
Anything else? No. That's all. Thank you.
All right, let's change it back up again. Let's go visit our friends in Louisiana, see what's going on there this morning.
Good morning. Today's date is December 8th, 2025. This is the Louisiana Committee on Parole. We're impaneled at headquarters in Baton Rouge, and we will be hearing offenders in Louisiana State Penitentiary first. But I'd like for the staff here at headquarters to introduce yourself.
Carla Williams.
And I would like for the staff there at LSP to introduce yourself before we get started.
Good morning, I'm Darrell Benoit, Warden. Ash Olivo, Deputy Warden.
Reginald Admiral, classification.
Carmen Chipley, Offender Records.
Thank you very much. The panel today is a 5-member panel by statute for offenders who have committed offenses against law enforcement. I will introduce the panel. To my far left is Chuck Tillis. To my immediate left is Danny Barra. To my right is Pete Freeman, and we have Mr. Steve Prater remote. So now, sir, would you please introduce your name and your DEC number?
Timothy Vollum, 477-228.
Mr. Vollum, for the record, you are a first-class offender. You are currently serving a 64-year sentence for the charges of attempted first-degree murder, obstruction of justice, attempted first-degree murder, and aggravated burglary. Does that sound correct?
Yes, ma'am.
Okay, you have a parole eligibility date 4/10/2023. You have a good time date of 4/13/2066 and a full term date of April 8th, 2067. Okay. At this time, I would like to acknowledge that we have several people in attendance there at LSP and on Zoom that are in your support. And we are going to, Mr. Barra is going to take lead on this case. Mr. Barra, I'm going to ask the supporters to speak first. Is that acceptable? Okay. So let's go ahead and have Lindsay County, your niece, speak. Catherine Vollum, your daughter, speak first. You also have Lindsay County and Gender County niece and sister who are not speaking, but Catherine Vollum will be. So you may speak at this time.
You can sit right there.
My name is Catherine, and I'm the only child of Timothy Vollum. I appreciate you taking the time to listen. I want to start by saying that I fully understand the seriousness of the actions that brought my dad to prison. I'm deeply grateful that the situation didn't end worse. Nothing I say here is meant to excuse what happened. Growing up without my dad has affected me in ways that I still feel today. I spent my entire childhood and young adulthood wondering what life might have been like if he had been present, and the absence has shaped me. Even now, as an adult and a parent myself, there's still a part of me that aches for the chance to have a real relationship with him. But I share this not to gain sympathy, only to show the long-term impact of his choices and why his growth matters to me personally. Over the past 24 years, my dad has had to learn lessons the hardest way possible. Before this offense, he had never faced long-term consequences for his actions. Family stepped in, he was released quickly, and he never truly understood the weight of trouble he caused. This time, he had no choice but to face himself. In these decades, I've watched him mature, change, and take responsibility for the man he used to be. He has held trustee status, worked consistently, completed programs, and has remained infraction-free for most of his sentence. He has lost both of his parents and a grandparent while incarcerated, and instead of becoming bitter, he became more reflective and aware of the damage his past behavior caused. I've seen a difference in him, not in dramatic words, because emotional expressions has never been his strength, but in his attitude, his consistency, and his effort to do right. He carries remorse, even if he struggles to show it in the way people expect. What he lacks in emotional expression, he makes up for in dependable behavior and a real desire to live differently. His sister and I are ready to support him if he is given the opportunity to come home. I'm not asking for special treatment, only for fair consideration of the man he has become after 24 years of growth and accountability. I believe he has changed. I believe he is safe to release, and I believe he deserves the chance to finish his life quietly, responsibly, and surrounded by family who will keep him on the right path. Thank you for your time and consideration for my dad's request for parole.
Very well spoken. Thank you. Mr. Kerry Myers with the Parole Project is also speaking on his behalf.
Yes, good morning. Kerry Myers with the Louisiana Parole Project. We're here for Mr. Volum. We're here. He had his first hearing 2 years ago. As this board knows, there are a couple of ways people can take a denial of a parole request, and one of them is to spiral. That is not what happened here. Mr. Volum's trajectory just continued to go forward. He's been a trustee for more than 7 years. He works on the carpenter crew. He's well trusted. He is a true first offender. This conviction, he has not had but 3 total disciplinary infractions during his incarceration, and the last one was 9 years ago. He's at an age right now, right at 49 years old, where he's in a place that he can easily be employed. He has skills. Parole Project is to accept Mr. Volum in our reentry support services that someone who's done more than 23 years in prison would need to readjust to life after prison. That'll include, obviously, being evaluated by our social workers so that he would follow any recommendations. That would also include mentoring with our case managers, direct support from that. The classes, obviously, things that he would need, technology and finance and consumer skills. We would also assist him with employment opportunities. So Mr. Volum, while he has served 24 years, he does have a 64-year sentence. He's in that right spot in his maturity, in his mindset. He committed an offense. We don't believe that Mr. Volum has necessarily has a criminal mentality. He committed a crime for which he has paid for and continues to pay for, and certainly recognize it. We believe he would do very well on supervision. And we support his release. So I'd ask this board to consider those things today.
Thank you very much. We do have Mr. Steve McCain, Sheriff of Grant Parish, who is here wishing to speak in opposition. Sir, so if you would take the podium and address the panel.
All right, thank you. I'm Steve McCain. I'm the Grant Parish Sheriff. Mr. Myers just mentioned that Timothy Volum committed an offense. Timothy Volum tried to kill 2 law enforcement professionals. He shot both of them But that wasn't enough. He shot one of them twice. Not only did he shoot two deputy sheriffs, he shot at the fabric of our society. And my request to you is to allow him to serve the sentence that was handed down by the judge that heard his case.
Thank you, Sheriff. Mr. Bob Wright?
All right. Mr. Bowler, would you tell us what actually you did? The sheriff gave us a little bit idea, but how did that go down, and why do you think now's a good time for you to be released on supervision?
Sir, you want me to?
Yeah, tell us what happened. Why did you shoot the cops?
I went out one night and stole a bunch of lumber. And while I was leaving, I was stopped by the two deputies. And when they pulled me over, they asked me where I'd got the lumber from and all of that. I was honest with them. I told them where I got it from. And the process of that, I asked them could I use the restroom, step to the side of the truck and use the restroom. And they told me that they was okay with that, and I stepped to the. I wasn't honest with them. I didn't tell them I had a gun on me. It was my intentions to take it and try to drop it on the ground, but everything just happened. So I panicked, and I know I should have told him I had a gun on me, but I panicked and I started shooting at him, and two of them was hit. I'm thankful that it wasn't worse than what it was, but I ran, and I was found about 3 miles from there.
Why do you think now's a good time for us to let you go, Bob?
Sir?
Why do you think now is a good time for us to let you go? What's different now?
I really don't think I deserve a chance for what I did. I know it could have been a whole lot worse. I'm just thankful that neither officers died from my actions. But yeah, I'm thankful that neither one died, but I do think that I'm a better person than what I used to be.
What have you learned about yourself in prison?
I've learned that I'm not the same person that I used to be. I know that much. I've learned growing up. I never respected the law, and I never really thought about what they do for everybody. But looking back now, I know what they do, and just them putting on their uniform every day and protecting everybody like they do. That it's more than I could say I could ever thank them for. It's just.
All right. Thank you. I need a note for the record that we have strong law enforcement opposition. The judge in this case is opposed, the DA's office is opposed, the sheriff's office is opposed, and the attorney general was not contacted. Does anybody have any questions?
Yeah.
Okay, could we get a little bit of input from the warden?
Good morning, yes, sir. Kerry kind of went over all his accomplishments. Here, he's been a model resident. He's quiet, only 3 DV reports. He's a Class A trustee, lives at F. He goes to work every day. Kind of like he is today is how he is every day. He's been zero problems here. He does a good job for us.
Thank you.
Thank you, Warden.
Anybody have any questions?
Mr. Prater, do you have any questions?
No, ma'am, I don't have any questions. The only thing concerns me, I hadn't heard a lot of remorse other than he's glad they didn't die. And of course, that's a two-edged sword. It's good for the deputies they didn't die, but what about him? It's also good for him because he'd have been serving a lot more sentence. So I'd like to hear what he thinks about the deputies now that what they had to go through and their families and their department and the community. And have you taken any victim awareness programming?
Yes, sir. He took it in 2 of 23. And he wrote the letter in 2 of 23.
Okay. All right. That's all I have.
If it's all right, Warden, could I read my letter for him?
If they'd like to hear it, that's up to the
Yes.
board.
It would be an appropriate time. Go ahead and read what you have.
Officer Chandler and Officer Abear. My name is Timothy Volleman, and I'm writing this letter humbly and respectfully in the account of accepting full responsibility for the crime of first-degree attempted murder, obstruction of justice, and aggravated burglary. I am grateful to be able to reflect on my past decisions, which led to an unlawful act that greatly affected the lives of many people. However, in this opportunity, I wanted to be able to translate my feelings and thoughts into words. My heart led me to be accountable for the decision I made that day that changed your life and my life forever. On March the 18th, 2004, many lives were affected due to my decision making as a 27-year-old man. I regret the decision I made that day every single day of my life. I had no right to alter your life, Officer Chandler, Officer Abear, or your family's lives. I had no right to impact your life emotionally, physically, or psychologically, spiritually, and financially. I realize the hurt I have caused many in my failure to act and be a better man. I apologize, and I am very remorseful for the grief, hurt, pain, agony, and anguish that each of you have went through because of my senseless act. I apologize for the financial wages you may have lost and the countless hours you have lost when you could have been peacefully serving the community. I'm truly remorseful for taking your sense of safety and your peace of mind. I humbly ask if you will consider my apology. While incarcerated, I've taken advantage of the opportunities which were afforded to me, such as different self-help programs. One in particular has touched my heart above all, the Victim Awareness Program. It has given me an understanding of accountability and empathy. My job here as a carpenter teach his on-job training and skills. I continue to be positive and live my life in that manner. After all the foregoing, my hope is this accountability letter is accepted as my sincere apology. I just want you to know I am truly sorry and I can't express it enough. Thank you.
Thank you, Mr. Fallon. Mr. Freeman, do you have any questions?
None. I'd just like to note that there are 12 other arrests on his rap sheet and some of them are violent. So I don't know whether he's got no criminal mentality came from.
So if there are no other questions from the panel, I believe we're prepared to vote. Mr. Balrog?
Mr. Vaughn, today I have to vote to deny your parole request based on the strong opposition from law enforcement, the strong and victim opposition, and you've only served a portion of your sentence that's imposed, but I think you're heading in the right direction. And I encourage you to keep up the good work and apply again.
Mr. Tillis?
I concur with Mr. Balrog. Not served enough time in strong law enforcement opposition.
Mr. Freeman?
Victim and law enforcement opposition, my vote is to deny.
Mr. Prater?
Concur.
And Mr. Ballum, you're doing a great job. I think that you understand that the time and the opposition, time will pass, opposition, hopefully what you've said today, people can see that maybe you're moving in the right direction, but my vote is also to deny. So this 5-member panel has voted to deny your parole. Thank you so much.
The last week or two since I had to rebuild OBS, every time we go to Louisiana, I remind myself that I still haven't set up those Michael Groff denied and approved stingers. So, denied. I know I don't do it as good as he does. I always find it funny in these where they'll tell them what a great job they're doing, but yet they're still denied. You're doing great, but my answer is no. Interesting. Anyways, let's go back up to Michigan. Judge Elmore, new contestant approaching.
All right, Mr. Clark is currently in pretrial custody. Also before the court is Ms. Dean Stark from the Community Corrections Program. You all may be seated. We are here today for a contested bond violation allegation hearing. Looks like the case was recently bound over from the district court. One moment. We were last on the record a week ago on December 1st. Allegation was that the defendant tested positive for methamphetamine. Like there were a couple tests given back on November 28th. All right, oh wait, you also asked for a test.
Your Honor, we don't have the test results back, but I anticipate Mr. Clark will be admitting responsibility for the bond violation.
All right.
For being positive for methamphetamine.
Mr. Clark, is that correct? That is correct. Raise your right hand to the best you can, sir. Do you swear or affirm the information testimony you're about to provide shall be the truth, whole truth, nothing but the truth? Yes, sir. You may lower your hand. All right, Mr. Clark, I'm told today you're going to waive that right to have a contested bond hearing. Is that correct?
That's correct.
Has anyone made any promises, threats, or inducements to force or compel you to waive that and make an admission today?
Yes, sir.
And you understand that if you make an admission and I accept that, the court can either continue bond as previously set, revoke it, or modify it. So is it true that on or about, I think it was the 28th, you failed to, you tested positive for methamphetamine? I should have said November 28th. Is that because you had used some methamphetamine? You knew that that was a violation of your conditions of your bond? Thank you. All right, Mr. Chair, are you aware of any promises, threats, inducements?
No, Your Honor.
All right, Miss Adult, sorry.
No, Your Honor.
I'm still getting used to it. Thank you, Ms. Dahl. All right, the court finds the defendant did violate his bond. Now the question is what do we do with him from this time? Ms. Dahl, have we had any prior violations? I don't remember.
He's violated before, but I think the violations were dismissed as part of an agreement for him to waive the preliminary hearing to be bound over.
Okay,
That's correct, Your Honor.
all right. Sorry, my pause was, just kind of seems a little awkward. Just for me, sharing this with counsel. Whenever you make an agreement that somebody will waive a right in exchange for dismissal of a charge versus the opposite way to say that, we will pursue you for if you don't. I'm just going to tell you that I'm not criticizing Judge Wiggins because he may not have known about it. If that were to raise to Mike, if it were in front of me, I wouldn't let it happen. I would never allow somebody to waive a right if they get a benefit. I mean, a pretrial agreement, something like that, but just be careful about how that ever sounds because it could really look bad. I think it does.
It was discussed in open court. The judge was fully aware of it.
As long as then I'm not going to second guess anybody. All right. So what are we doing today? Your position, Ms. Dahl?
Well, Your Honor, I was made aware that Mr. Clark has been available at Sunrise Center from Mr. Cherry here. I'm not opposed to him.
When's that made available?
December 10th, Your Honor, at 1 o'clock.
I can tell you, yeah, all right.
Your Honor, I just, the people's position in this case is if he does get released to inpatient treatment, that all of the other conditions of bond remain, that he continue to be randomly tested once he is out of inpatient treatment, and that he follow all the recommendations of inpatient treatment when he is released and has aftercare instructions. The reason for that is rehab sometimes is meaningless if they do nothing after rehab and continue on with the lifestyle that they had and made no significant changes in their life. So in order for him to remain clean, he will have to put in some work. So we are not opposed to him going into inpatient treatment as long as he goes directly from jail to inpatient treatment and immediately follows any recommendations he has for aftercare and continues on with the drug testing and other bond conditions that he's previously had. Thank you.
Yes, sir.
We would have absolutely no objection to any of the requirements that the prosecution just laid out. I think that's consistent with what this court has done in similar situations in the past, which is immediate release. If you leave early, you go back to jail. When you get out, you comply with all terms of bond. So I think that makes sense. The only one thing that I did want to point out for the court is Mr. Clark's drug history is relatively short. It began in 2020 with a possession of methamphetamine, and that is his only prior drug charge or conviction. And so we're dealing with a relatively short period of time over a lifespan, and he has not sought rehab previously. And I believe that this opportunity will be good for him. What I also want to share with the court is the reason we asked for the test to be done was not that we were contesting whether or not it was going to be positive, but because we wanted the quantities. I will represent to the court that I anticipated would have been trace quantities based on when Mr. Clark told me he had used. Essentially, he thought because of the prior missed tests, he was going to go to jail, and he kind of gave up. And he succumbed to his lack of coping mechanisms that he will get in rehab. And that is why he tested positive on the 28th. In terms of the prior alleged bond violations, I know the court talked about them. I'm not sure the court should consider them in this bond violation because there were no convictions.
Well, there are no convictions, but there's no rule of evidence that applies.
I understand. I'm talking about what I think the court should consider.
Yeah. Okay.
And so, for all those reasons, I think that rehab is a good option. I think that a good long time there for him to get the coping mechanism so that he doesn't have another relapse would be very beneficial. Thank you.
Ms. Stark, tell me about how he's done on bond and testing. I see some of this information here. Why don't you go ahead and give me a summary, because his failure to show or appear is my quintessential issue, because if I let people out on bond, especially when there has been no resolution of the case, they almost always disappear. So I'm not likely to grant it. Now, that does sound a little awkward considering what I said earlier, but if I've got a person who's got failures to show, has he failed to show up for testing?
3 times.
Yeah, I'm not gonna put him into a program until I know he's gonna show, and I have no leverage over him without a resolution. Because I don't know if he's gonna show. I'm just gonna tell you, when a defendant goes to a rehab program and the charge hasn't resolved, they always disappear. So, and especially when they have failed to appear for just testing. Could you imagine if they fail to appear for testing, and then over here I've got a hanging charge over them that's got a 10-year plus a HAB 3, which makes it a 20-year and impacts his guideline range, which I'm going to have to suspect his guideline range here would be a 5 or 10 to 23, based upon that's just random guessing at the HAB 3. So, yeah. So, yeah, I've got a person who fails to appear and test positive when he knows he's going to test positive. I'm not likely to modify his bond and send him to a treatment program and let him out on a PR, because he already has proven to me he isn't going to appear if he doesn't want to. So the answer is no, I will not modify the bond as to that. Now, if he chooses to go, that's something different on his own, but that's going to be whether or not there is a bond set. It looks like he had a bond which he posted back on November 5th. Was that something he posted, or was that a bail bondsman?
It was a bail bondsman, Your Honor.
Okay. And while I know somebody tests positive and that I'm using that to argue that is, and I'm not trying to pick too much on Mr. Cherry, but here's how I see it. He's already guilty of another felony. Never really, it's not charged that way. But if he used meth, he possessed meth, that means he's guilty of, at least in my mind, another felony. So he's got he's got issues with methamphetamine, and while he only has one conviction, in effect, he's admitted to another one. It's not a crime. It won't be counted as a crime, but it definitely will count as reasonable grounds and things I can consider as sentencing. So, again, I tend not to, especially if somebody's shown that they have a pattern of failing to show up for testing. It's a contract. You sit in jail, or you do the things we the judges tell you to do. And if you choose not to do the things we tell you to do, which by the way are designed to keep you healthy and safe so you don't do anything stupid, then you breach the contract. So my question is what do I have to do? $15,000 in jail hanging over his head didn't work. Do I increase the amount or do I revoke it? That's my question. Was Are you doing anything like going out to rehab when you're out?
I was trying to get to rehab, but they kept adjourning my case and.
Okay, well, here's what I'm gonna do. Yeah, go ahead.
I think this part is important for the court to consider. He was working when he missed those tests, so he doesn't have transportation, so he's getting rides to work, but he couldn't get a ride to rehab or to testing. So he was working, he has a job.
He's already willing to forego the job to go to a treatment program.
Correct, Your Honor. That's correct.
Yeah, so I understand.
He is right. We were waiting on the letter from Sunrise Center while the case was in district.
The court is going to revoke bond, remand the custody of the Wexford County Jail. Hopefully we can get this case moving along. Thank you. We're adjourned.
Okie dokie, friends. New contestant in Louisiana. Let's go back there.
Louisiana Committee on Parole is impaneled in headquarters in Baton Rouge. This is a 5-member panel by statute. Serving today remote is Mr. Steve Prater. To my far left is Mr. Chuck Tillis. To my immediate left, Mr. Danny Barra. To my right, Pete Freeman. I'm Jerry Ledoux. We are going to be reading some information into the record. But first, would you please introduce yourself, the offender? Introduce yourself, please.
Oh, yes, ma'am. My name is Oscar James Penton Jr., and my DOC number is 460038.
Okay, Mr. Penton. We find that you are a second-class offender. You're currently serving a 50-year sentence for first-degree robbery, possession of oxycodone, for second-degree kidnapping, disarming a police officer, aggravated escape, and aggravated assault on a police officer. You have a parole eligibility date of March 5th, 2026, a good time date of 6/7/2038, and a full term date of 12/2/2051. Does that sound correct?
Yes, ma'am.
Okay. At this time, I'd like to ask the warden if he would like to make a statement.
Yes, ma'am. He's a medium custody assigned to MAG 2. He's a mentor. He's had ADB reports. He's taken a lot of programming since he's been here. I could go through the list if you like for me to, or if y'all have it, but he's taken a lot of programs since he's been here. Really, his conduct record's good. He does a lot of things. He's a certified tutor. He's had trauma healing, TYRO leadership facilitator, celebrate recovery, anger management, 100 hours, thinking for a change, inside out dads, IC3, substance abuse. He has his GED.
Thank you, warden. Appreciate your comments. Mr. Penton, before I acknowledge all of your supporters, well, I can go ahead and do that. I'm going to read off those who are not speaking at this time. Mr. Chris Allman, Amy Allman, Dania Smith, Trenton Smith, Deja Allman, Destiny Allman, Pam Riley, Greg Riley, Nancy Greer, Edward Greer, and Erica Leatherman. And then we do have some that are speaking, and I'll let them do that. Before we do that, though, I'd like to ask you to explain to me, so also Ms. Hogan, I apologize, Ms. Hogan, you're here, and you will have an opportunity to speak as well. I would like to have the offender, though, tell us why you are currently incarcerated and why today is the day you think you should be paroled.
Yes, ma'am. So that story really must begin in 1998. I broke my leg playing a sport called hacky sack, and I had to have surgery on my leg. They put a plate and screws in my leg. After that surgery, they started prescribing me medications to to deal with the pain management of that surgery. And my life was really a downward spiral from that point forward. I became really addicted to drugs and was pain medications and taking way more than I probably should have. Eventually, I was introduced to Oxycontin, and that was a further downward spiral. I started using those intravenously, and that downward spiral continued until the year 2003, where I went into a pharmacy in broad daylight with a BB pistol to rob that pharmacy for Oxycontins. Shortly after that, I was apprehended for that robbery and brought to the parish jail. And while I was in the parish jail, I started having seizures and withdrawals coming off of those Oxycontins. They rushed me by ambulance to the LSU Regional Medical Center, and they committed me as a patient to that ICU ward. While I was on an ICU ward, I was being heavily medicated for the withdrawal symptoms, and they left my left hand unrestrained, and I disarmed the guarding officer that was guarding me. Apparently held the gun up to my own head. Apparently irrationally started demanding Oxycontins and cigarettes. The weapon was discharged into the baseboard during that incident, and I can't tell this board why. I honestly cannot tell this board why that happened that day. Most of those memories of that event are completely surreal and vague at best. So they apprehended me, and I ended up with a 50-year sentence from that incident. As to why this board, why I think this board should grant me parole, I've written something from my heart. My attorneys asked me to speak to you guys, but it's a little easier for me. Is this okay to read it?
Be fine.
Okay. Over the years of my imprisonment, it has been common for me to tell people that I wasn't arrested but rescued. That fact is more true than I could ever hope to express here today. I want this board to know that I absolutely accept responsibility for my actions and crimes. I wish with everything in me that I would have sought help before it ever escalated to such a point of tragedy as it surely did in my case. To this day, I cannot believe that it never crossed my mind to simply have asked for help. I am so sorry that I allowed my addiction to lead where it did. It truly was an absolute tragedy for all those that were involved, including myself and my family. I am sorry to all that were affected, to Mr. Burkhalter and his clerk at the pharmacy that I robbed, and to the officers, staff, and patients that were present in the hospital during the hostage situation that I was implicit in, and especially to Nurse Susan Smith, Deputy Glenn Sheridan, and Deputy Vernon Smith, especially. I've often wished that it were possible for me to personally express my sorrow to these individuals over the years, for them to have known me before drugs, or for them to know the man that I've come in the years since. The hardest part has honestly been forgiving myself, but I realized that I could not allow these things to define the person that I am or to prevent me from becoming the man that I have become. Please know that I'm celebrating nearly 23 years of sobriety, and perhaps more importantly, I'm celebrating life, my own and the lives of others. I am grateful for this opportunity to be here today, and I would like this board to know that I have been committed to change and self-improvement from the very beginning of my imprisonment, and for many years before I even had parole eligibility. That commitment is for the sake and necessity of change itself. I am before this board today seeking mercy and another chance at freedom, a chance to build and have a life beyond prison walls before I'm too old to do so. Please know that I'm completely aware of the responsibility that weighs on this board's shoulders when it comes to a decision to grant me that chance. But in addition to that responsibility, there is also the power to grant new life and second chances. Other than a record and the beautiful testimonies before this board, I only have one further thing to offer, and that is my word. People can and do change. And if I promise this board finds favor and mercy for me here today, that trust will not be violated and that mercy will not be taken for granted. Thank you.
Thank you, Mr. Penton. Respect from the heart. We also, Ms. Hogan, I'm going to allow the family members to speak and let you speak, if that's acceptable, okay?
That's fine.
Stephanie Greer, your fiance, would like to speak. You can just sit where you are and speak loudly. We can hear you.
I'm Jim's fiance, Stephanie Greer, and soon to be his wife. We're getting married in January. And I appreciate you all letting me share with you what I see in Jim and why I believe he's ready to come home. When I first met Jim, I had no interest at all in a romantic relationship with an inmate. But I felt this strange, I felt compelled to write to him. I had grown up in a very healthy, very stable home where there was a lot of integrity, a lot of spiritual awareness. And I almost immediately saw something in Jim that I was not expecting. I saw a substance and a quality and an honesty in him. And after our first serious conversation, I remember just whispering to myself, I may have just found him. I saw in Jim, he was very spiritually sensitive. He was articulate, intelligent, talented. He was gentle, perceptive, but also very strong. He did not put on a mask or a religious facade. He didn't whitewash his flaws. He was raw and real, and he insisted on being very open and transparent with me from the very beginning. And he was full of yearning for life. And I knew right away that this was a man with a future. When I told my rather protective dad about our budding relationship, I was shocked by Dad's response. He and Mom were both wide open to Jim from the very beginning, despite his situation. They traveled with me 12 hours from North Carolina to meet him more than once. My dad actually had a background in prison ministry, and later he owned a Christian personnel and job placement service. So he's really good at discerning people's hearts, their character, and their talents. I hope you all had a chance to read the letter that my dad wrote and with his observations of Jim. My parents are both here today. My siblings and their families are all watching online. They've all believed in Jim and been rooting for us. Jim's family and friends also confirmed the impressions that I had of him. His Uncle Marvin told me that Jim had been a truly excellent young man and he never would have gotten into trouble if it had not been for that drug addiction that started after his surgery when he was a teenager. When he worked in sales, his employer talked about how impressed he was with how well Jim interacted with clients and how comfortable people were with him. His mother remembered when he was a boy how he loved to choose picnic spots for outings with her and his younger siblings, or how he used to get driftwood from the river and he would design these beautiful flower beds and use his own spending money to buy flowers to put in them. His cousin Robin told me that she remembered him playing with her son as a child, and she repeatedly said, he was such a sweet boy, such a sweet boy. This is the Jim Penton that I know. He's beloved by everyone who knows him. He keeps his work area at a high level of excellence. He makes opportunities to counsel and enrich his students who adore him. He suggests unique gifts for my family and his, and even for other inmates. He reads and he discusses books with me. He pays attention to detail, and he's constantly offering creative suggestions for improving my life. He's pushed me to grow and develop myself. He encourages me to cherish things that really matter and not take anything for granted. Everyone who knows him tells me again and again what an excellent man he is. Jim and I plan to live in my home with family nearby and keep renovating and developing the land that I inherited from my grandparents. Jim and I will both attend Celebrate Recovery meetings together at a church nearby, and we will involve ourselves in a local church. My church family and friends have all accepted Jim with open arms. He has multiple job offers in North Carolina and an entire community waiting to receive him. Quite a few of them are also watching this hearing in support from North Carolina and other places, and everyone is praying for Jim to have a second chance. Jim has not seen trees or stars in 23 years.
You need to wrap up.
I'm asking you to let him come home with me and see the mountains while we're both still young enough to build a home and a life together. Thank you.
Thank you very much. We do have a couple of others who would like to speak. Your brother, Derek Penton, would like to speak.
He's not here.
He's on Zoom, but I think actually the speakers were going to be Stephanie and Chris Allman, who's Jim's brother-in-law.
Okay, so Mr. Penton's not going to be speaking via Zoom.
Yes, ma'am.
Okay, so Mr. Chris Allman, if you'd like to go now, it took about 3 minutes.
Thank you. My name is Chris Allman, and I'm a minister of 12 years. I'm also Jim Penton's brother-in-law. I've known Jim before he went to prison. My wife, Amy, is his sister. She and I have been married for over 23 years. We have 3 beautiful daughters. We previously pastored for over 10 years. Currently, we are business owners in the auto and trucking industry. It's been since the age of 18 we have visited Jim countless times, and we have been really proud to see his tremendous progression in humility, knowledge, and determination to learn useful skills over the years. There's so many of his achievements I could elaborate about, especially his certifications in auto mechanics, computer technology, all the recovery programs. But at this time, I'd like to share something from my wife, Jim's sister. She's a little bit uncomfortable speaking in public, but she's written something from her heart for her brother. Amy wrote, "I would like to share some special memories about my brother, James Penton, who my family knows as Jim, to give you a sense of who he is. Jim was the protective older brother who always looked out for me and didn't mind riding his little sister around in his truck, jamming to some of our favorite music. Jim was the son who saw his overwhelmed mother of 5 and decided to rally his younger siblings to prepare an entire Christmas dinner while mom was grocery shopping. She still talks about this today. Jim was the busy employee who paid his little sister to call around, offering free estimates on vinyl siding. Jim was the uncle who made his nieces feel comfortable in an uncomfortable place, like a prison visiting room, joking around and inventing silly games for them to play. Jim was the caring adult who didn't hesitate to say yes when my daughter of 15 asked to interview him about his experience with drug addiction. It was an assignment that she shared with her class. He wanted so much to warn young people not to go down that road of addiction. Jim's fiance, lastly, Stephanie, is a good friend, so encouraging, so kind, and a genuinely great person. For someone like her to unconditionally love and commit her life to him, well, that's just another proof that there's greatness in Jim. Yes, Jim has made some bad decisions, but he is a good person who made the best of his situation he found himself in. His addiction resulted in devastating consequences, but now he is joyful, hopeful, and caring. He was not destroyed, but restored. He is saved and he is free. And we're believing he's ready for a new beginning. Sincerely, from his sister, Amy. And I just want to say, with this new beginning, our family, all of us here, we're really willing to help and support him in any way needed to ensure that he is successful in society. We want to encourage him to have a different life and a different future. And I know he wants the same. I just want to thank you so much today for allowing us to share our hearts with you today. God bless y'all.
Thank you, both to Chris and Amy. We have Kerry Myers with the Parole Project.
Yes, good morning, Kerry Myers with Louisiana Parole Project. I'm not going to continue to just repeat everything that's been said about Jim. Parole Project has accepted him. He will participate in our program. We'll get the full services we have to offer during his initial transition. It is his goal, as was stated, he is to be married in January. His parole eligibility date is March 5th of 26. He will, once it come with Parole Project and complete phase 1, he would also, during that time, have initiated an ICOTS to his permanent residence in North Carolina. We would just, and obviously you see the support that he has in North Carolina. We just asked this board to consider those things today and grant this dependent in his parole.
Thank you. Hogan, it's your turn now.
Yes, ma'am. Thank you. I want to first acknowledge that I know that this is a very difficult case for the board. I know all cases are difficult, but I know that this is a particularly difficult case for the board. And I want to also acknowledge that the motive and the reasons behind Jim Penton's crime do not minimize the fact that there were crimes and that there are victims in this case. And the reasons that he committed his crimes don't make that experience of what happened any less traumatizing or harrowing for the people that lived through it. But as far as looking at, for purposes of today, for deciding a parole hearing, the reasons that somebody commits crimes is a significant factor, because this board looks at whether the defects that brought someone to prison have been corrected through the Department of Public Safety and Corrections. And in looking at this case, the motivations for Jim's crimes are all over the police report. He robbed a pharmacy not for money, but for Oxycontin, and then the situation in the hospital, he was not demanding anything other than Oxycontin and cigarettes during that situation in the intensive care unit. That's not to minimize or to justify what has happened. And Jim Penton is the first person to tell you that it is his fault for allowing his addiction to get such a hold of him that he was victimizing innocent people. He's the first person to say that whenever he was walking into the pharmacy, there was a hospital right there. And instead of walking into the hospital and demanding help, he chose to walk into the pharmacy. He admitted his crimes right after being apprehended, and he pled guilty. The first moment that he was offered a plea bargain was in the middle of trial, and he accepted it because he was in fact guilty. Throughout the last 22, almost 23 years, the reasons behind the crime, the serious drug addiction, have been corrected. He's taken all substance abuse classes that were offered to him. As he stated, he has been completely drug-free from the moment of his incarceration. He is also currently a vocational reentry mentor, and there are several letters in the packet of materials that I submitted from mentees, from co-mentors, from staff at Angola, all praising him and saying that he's an inspiration, and that he goes out of his way to give back to others and to not only educate them about automotive technological information, but also to share his testimony and to be there on a personal level. Also within the packet of materials are 2 letters of support from, one of them is from retired Judge Rusty Knight, who started the reentry program here at Angola, who knows Jim personally and believes that he is worthy of a second chance. There's also a letter of support from current Judge William Burris, who inherited his father's bench in Washington Parish, and Judge Burris met Jim at a reentry event several years ago, spoke to him for over an hour, and believes that he is worthy of a second chance. So for all of these reasons and all of the things that Jim has done to remedy the reasons that brought him to prison, while not minimizing them, we would ask this board to impose any condition that it wants to, that it sees fit, but to ultimately allow him early release on parole.
Thank you, Ms. Hogan. Before we go any further, I'd like to ask Warden Vanoy, could you help me understand the write-up in 2025, recent write-up? Yeah.
He had a tablet that had been altered.
Was that a high or low court write-up, sir?
That's low.
Low.
Yes, sir.
Okay. And that doesn't cause you any concern? I don't know.
Altered tab.
On his tablet, yeah.
Something, the battery was turned upside down or something?
Well, yeah, the battery number was upside down.
So that's why he said he altered.
It had an app on it that didn't belong on it.
Thank you. I noticed that and wanted to ask if that was higher.
It didn't have anything in it.
It was a files app, it says.
Yeah.
Some kind of files app.
A file, yeah. I was trying to see what penalty they gave him.
A reprimand,
A
sir.
verbal reprimand.
Yeah, he got a verbal reprimand for that, right?
Okay. I just noted that and wanted to make sure I brought that up. At this time, we do have the ADA of Washington Parish, Butch Wilson, with us via Zoom, and we'd like for him to speak at this time.
He's on mute.
I think you're on mute, sir.
Is that better?
Yes, sir.
Oh, good morning. I'll be brief in my comments. Mr. Penton, this offender blames the conduct that we're discussing here today on drug addiction. And I think we're all well aware that the vast majority of people who have had issues with OxyContin have not acted out in the fashion that Mr. Penton did, which means that we're left in a situation where if this board is going to grant parole, they're going to have to trust this man once he's released to stay away from dope. On behalf of law enforcement, we are not willing to take this chance based upon these facts. And these facts are amply detailed in the opposition of retired Deputy Vernon Smith, who Mr. Penton, for whatever reason, neglected to mention today when he was going through what happened. Mr. Smith was put on his knees and had a gun to his head. He witnessed a nurse being used as a human shield. He vehemently opposes parole in this case. And we think that the board should take what he has to say into strong consideration. This conduct was simply too egregious. It was. And we don't think that on law enforcement, at least, we just cannot trust an offender like this, that once he's released from custody, that he's going to stay away from what got him in trouble in the first place. And on that basis, and the statement of Deputy Smith in this case, we respectfully oppose parole. Thank you.
Thank you so much. Appreciate your testimony. Do any of my colleagues have any questions? Mr. Prater?
Have any questions?
Mr. Tillis?
No, I don't have any. No questions.
I move for an executive session.
I second.
So we have a motion and a second. Roll.
Tillis,
Yes.
Valor,
Yes.
Ledoux,
Yes.
Freeman,
Yes.
Prater.
Yes.
All right, we are on the Wayback Machine, so let's bump this forward.
5 factors to determine, usually when somebody's ready to prove themselves on the street. Today, based on your excellent rehabilitative process, your conduct, I would lean towards granting you. I'm not concerned at this point about public safety. Time served is a little on the low side, but today my vote would be to grant parole with some stipulations that you continue to do substance abuse treatment on the street. Mr. Baum.
Thank you.
I would concur with Ms. Ledoux and the grant to parole project and no contact with any of the victims or their family.
Thank you.
Mr. Freeman, sorry.
My vote is gonna go along the same lines, but I think you need to finish Steve Hoyle or inpatient substance abuse. I know you hadn't used in 23 years, but it's the best we got to offer. So mine would be to grant contingent on completing Steve Hoyle or a DOC program.
Okay, Mr. Tillis.
My vote's going to be to deny due to law enforcement opposition.
And Mr. Prater.
Yes, ma'am. I'm trying to get back on the video. The host is still denying me, but I have okay, now I've heard everything I've been on, but I just hadn't been able to, you hadn't seen my picture. I think that in a case this serious, and we all have this reservation about what to do with this particular case. This is a real heart-tugging case, but I think because of the fact has not even served 1/2 of his sentence, I would have to concur with Mr. Tillis because of the objection of law enforcement and the victims in this case. They need to spend a little more time in it, but that's, I know it's discouraging, but it's not meant to discourage him. There is light at the end of the tunnel. I concur with Mr. Tillis to deny.
So I want to vote to 3-2. Sir, your request for parole has been denied. The time is now 10:07, and that concludes the hearing there at Louisiana State Penitentiary. Thank you, staff.
Interesting result there. Not a unanimous denial, which I thought it might be. You never know what the sport is going to do. I've said it before. That's the reason why I go here. There's a lot of very interesting stories, and you just never know how they're going to turn out. So there we go again. Okie dokie, friends, that does it for today. I hope you all had fun. We'll be back tomorrow, of course, 10 a.m. Eastern, 7 a.m. Pacific. So join me then. In the meantime, go have yourselves a great Monday. Make it the best it can be, because this is the only Monday, December 8th of the year of our Lord 2025 you're ever going to see. So make it the best you can. Take care. God bless.